Morning.
Good morning.
Time is now 10 a.m. and I'd like to call the July 10th Planning Board meeting to order. We have the following board members with us today: Vice Chair Bailey, Commissioner Washington,
Good morning.
and Commissioner Giraldo.
Good morning.
For the record, I am the chairman, Darrell Barnes. We now move forward to the business at hand. Please note that the deadlines for all participation pre-registration and all submission of materials and exhibits was due 12 noon on Tuesday before this planning board meeting. Staff is available today for on-site registration or if you require assistance. But now we will move into today's agenda. The order of cases for today's meeting is as follows. Items 2, 3B, 4A, 4B, and 4D. 5, 6, 7, 7B, 7. I'm sorry, 8A and 8B. The first item on the agenda, item 2, draft minutes of June 26, 2025. We look for a motion to approve the minutes for June 26.
Motion to approve minutes of June 26th.
Second, Mr. Chair.
We have a motion by Commissioner Bailey and second by Commissioner Giraldo. I will now call the roll. Vice Chair Bailey,
Aye.
Commissioner Washington,
Vote aye.
Commissioner Giraldo,
I vote aye.
and I vote aye. The yeas have it, and the minutes have been accepted. I would like to call us into an executive session. The following is my closing statement. Pursuant to general provisions article of the Annotated Code of Maryland, Arts 305, subsection B1, item 2 and 13, a closed session is proposed to discuss a personal matter concerning an appointed position in the Department of Parks and Recreation and to comply with the specifics, constitutional, statutory, or judiciary imposed requirements as prevents public disclosure about a particular proceeding. Commissioners, do we have a motion to convene into a special session?
So moved, Mr. Chair.
Second.
It has been motioned by Commissioner Giraldo and Commissioner Washington. I will now call the roll. Vice Chair Bailey, Commissioner Washington,
Vote aye.
Commissioner Giraldo,
Vote aye.
and I vote aye. The ayes have it. We will reconvene to an open session following the executive session meeting. Thank you. This was the motion to go in, right? Executive session, I've got to, it says approve the.
That was for the minutes. We did that. That was for inside the closed session. They were giving you a script in there. So now we're going to move to consent and then 5, 6, 7, 8.
Okay.
Yeah.
Maybe she can get promotions. I should.
We will now move forward with the consent agenda, items 4A, 4B, and 4D.
Mr. Chairman, after consideration of the records for items 4A, 4B, and 4D, I move adoption of the staff findings and approval of these items on the consent agenda in accordance with the recommendation of staff. Second.
Good. We have a motion by Commissioner Bailey and second by Commissioner Washington. I will now call the roll. Commissioner Bailey,
Vote aye.
Commissioner Washington, Commissioner Giraldo,
I vote aye, Mr. Chair.
and I vote aye as well. The ayes have it. Regular agenda items. We will now move into the regular agenda items. The first item on the agenda is item 5, conceptual site plan, CSP 23002, Signature Club East, evidentiary hearing.
Staff is ready.
Staff?
Hold it for 3 seconds. It was ready.
So you,
Good morning, Mr. Chair and the member planning board. For the record, my name is Emery Guang with Urban Design Sections. Item number 5 is the conceptual site plan CSP-23002 for the Signature Club East. This conceptual site plan is for the development of up to 300 multi-family dwelling units and 12,600 square feet of the commercial retail spaces. As a matter of housekeeping, staff received one exhibit from the applicants prior to the Tuesday noon deadline, which is titled Applicants Exhibit 1. Staff also received one inquiry from the owner of the property abutting the subject property and 5 opposition exhibits titled Opposition Exhibits 1 through 5. Concerns raised by the community members will be discussed later in the presentation. Finally, staff provided one exhibit titled Staff Exhibit 1, outlining correction to the analysis of Type 1 tree conservation plans on page 32 of the technical staff report. Staff will make updates in the resolution reflecting these corrections. Next slide, please. The subject property is located in the planning area 84 and council district 9. Next slide, please. The subject property is located in the northeast quadrant of the intersection MD 228 Ferry Road and Manning Road East. Next slide, please. The subject site outlined in red is currently located within the residential multifamily 48 zones, as shown in the image to the right. However, this application is reviewed under the prior zoning ordinance, and his prior zone is mixed-use transportation oriented, as shown in the image to the left. Next slide, please. This map shows the topography of the site, specifically the site slopes downward from the southwest of the site to the northeast side of the property. Next slide, please. The subject property is bounded by 2 master planned rights-of-way, which are MD 228 Berry Road, classified as an expression way, and Manning Road is classified as primary road. Next slide, please. The subject property is currently vacant with tree coverage. Next slide. So for this subject development consists of lot 12 and out parcel B. It's worth noting that lot 12 was formerly lot 3, the conceptual site plan CSP-99050 approved by the planning board in 2000. Lot 12 was approved for a total of 157,100 square feet of the commercial space, including 10,000 square feet of the office space. In addition, condition 1G of CSP-99050 notes the maximum height of the office structures to be 3 to 4 stories. Next slide. Parcel B was not part of the CSP-99050. In 2006, the district council approved the zoning map amendment A-9960-C to rezone the out parcel B to the MXT zone on the rural residential zones. Subsequently, the applicants combined both lot 12 and out parcel B for the subject conceptual site plan as a new application, rather than an amendment to CSP-99050. The subject application was accepted prior to April 1st, 2025. Therefore, the applicants elected to have this application to be reviewed under the prior zoning ordinance. This image on the screen also shows the relationship between the subject property and ND 228, ND 210, and ND 373. Next slide, please. The conceptual site plans propose multi-family dwellings, commercial retail uses, which are compatible with adjacent residential and commercial developments. The commercial pad sites are conceptually shown to be located in the southern portion of the property, fronting MD 228, and the proposed multi-dwelling buildings to be located in the northern portion of the property. The anticipated building heights of the commercial and residential structure proposed for the subjective development generally align with the maximum building heights previously approved for Part 3 under CSP-99050. The proposed developments also offer additional housing options and the opportunity for existing and future residents to patronize locally. Next slide, please. The location, the conceptual plan showing the pedestrian and vehicular circulation within the development. The proposed pedestrian circulation is designed to support safe pedestrian access to the proposed buildings on site and to off-site sidewalks. Next slide, please. This slide shows the subject size outlined in red and demonstrates the tree conservation plan, which is discussed on page 31 through page 32 of the technical staff report. Woodland clearing is consistent with the prior tree conservation plan approval for the site, with woodland conservation to be met on site. In addition, a variance to section 25-122B1G is requested for the removal of 4 specimen trees, which is discussed on pages 35 through 38 of the technical staff report. Next slide, please. As mentioned at the beginning of this presentation, one exhibit submitted by the applicants, including the applicant's proposed revisions to condition 1C and condition 2D, along with supporting reasons. The applicants also acknowledge that no changes are proposed to condition 2A, but the applicants identify 2 locations within the property where sidewalks are not to be included, and this will be addressed at the time of the detailed site. The staff are in agreement with the proposed revisions and the applicant's explanation because this revision will not alter the intent of the conditions and provide the flexibility in addressing them. In this exhibit, the applicants also provide an explanation of their disagreement with the transportation section analysis presented on the pages 18 through 21 of the technical staff report for records keeping purposes, and acknowledge that these issues will be further evaluated at the time of the preliminary plan of subdivisions. Concerns raised by the community members in 1 inquiry and 5 opposition exhibits can be grouped into several categories, including transportation and infrastructure, environment, and school overcrowding, compatibility, and inconsistent with the prior approvals. Staff have provided responses to some of the concerns throughout the presentation. Staff also want to note that these conceptual site plans provide the preliminary schematic plans for the development of the subject site. Per the zoning ordinance, subdivisions regulations, a detailed analysis of infrastructure impact, such as but not limited to transportations, public safety responsive time, environmental impact, and park facility will take place at the time of the preliminary plan of subdivisions. With respect to the transportation infrastructure, specifically in approving this conceptual site plan, the planning board is required to find the transportation facility they are existing under construction or fully funded are adequate to carry the anticipated traffic for the proposed development. This finding is analyzed on pages 18 through 21 of the technical staff report based on the traffic impact study submitted by the applicants and dated May 23rd, 2025. Further analysis of transportation adequacy will occur throughout the certificate of adequacy, which is required to be obtained at the time of the preliminary plan of subdivision. Based on the findings presented in the technical staff report, Urban Design Staff recommended the planning board adopt the findings of this report and approve the conceptual site plan CSP-23002, type 1 tree conservation, TCP 1-052-97-03, and the variance to the section 55-122 B1G for the signature clause, subject to the recommended conditions approval within the technical staff report as modified by Staff Exhibit 1 and the revision proposed by the applicants and agreed upon by the staff in the applicant's Exhibit 1. This concludes staff presentation. Thank you so much.
Thank you. Now, are there any questions from the planning board?
None
None,
at this time.
Mr. Chair.
Thank you.
Unfortunately, the technology is not working on our side, so we're going to take a 3 to 5 minute break so we can try to get the live stream back up and running.
Thank you.
David, you want to?
Sure. Thank you, Chair Barnes. Prior to proceeding with the testimony from the public, pursuant to 6.4B of the Planning Board's Rules of Procedure, persons that intend to provide oral testimony have to be sworn in. So if you're in the crowd and intend to speak on this matter, please stand, raise your right hand. And if you are appearing virtually, please do so at home. And I like that we've got some young customers here today. That's something we need more of. Raise your right hand.
Are we going to get verification at the photo? Using the right hand, because I don't really see it. I understand you've requested attorneys to raise their hands too, so.
Please do.
Good.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I did.
Thank you.
Thank you all. We will now hear from the applicant's attorney, Mr. Gibbs.
Thank you very much. Good morning, Mr. Chairman. Welcome.
Thank you.
I'm pleased that I have the opportunity to be the first presenter in your new role as chairman of the planning board. Welcome. I was at your work session introductory meeting in front of the county council, and there were some pretty amazing things that were very, very positive in nature said about you, and so I'm very happy for you to be here as chairman of the planning board.
Thank you.
My name is Edward Gibbs, and I am an attorney with offices right here in Largo, actually directly down the street. I'm on Caraway Court, 1300 Caraway Court. I am pleased to be here this morning representing the applicant, WP Acquisitions, LLC, and that limited liability company is really comprised primarily of an entity known as Wood Partners. Wood Partners builds and owns multifamily developments really across the United States. I've had the good fortune to be able to represent them for over 20 years here in Prince George's County. They have, I think it's 6 different projects that they have constructed, starting with my family's home that they bought adjacent to the Branch Avenue Metro Station, where they built a multifamily project. They have built other projects as well, including in the heart of College Park on Route 1. They have recently had a multifamily project approved in Woodmore Town Center. So they are no strangers to Prince George's County, and they are, in my opinion, remarkable developers, stewards of the land and of their projects, and very responsive to concerns that people may raise at any given time. Mr. Scott Zimmerly is seated in the front row. He's really in charge of their East Coast operations. He has pretty much, I think, with the exception of the very first project, he has shepherded all of the other projects for Wood Partners here in Prince George's County. Another member of Wood Partners, Mr. Zachary Albert, is here sitting directly behind him. And so here's what I'm going to do. I'm going to orient you to what is going on here. I am going to adopt my statement of justification, my application, the studies that we have already put into the record, and for the most part, the technical staff report in this case. There are 15 people signed up in opposition. I cannot anticipate everything they're going to say. If I try to do that in the initial part of my case, I am going to be here a lot longer than you want me to. So what I'm going to do is do that initial presentation, and then I'm going to sit down and I'm going to listen to the issues that are raised, and then I will address them in my rebuttal to the case. And I did verify with Mr. Warner just a minute ago that that would be an appropriate procedure. Hopefully it is. Otherwise, I'll have to go through everything right now. So let me start out by saying that what we're dealing with today is 16.9 acres located in the northeast quadrant of the intersection of Berry Road and Manning Road East in the Accokeek area. We have two different parcels. We have Lot 12, and then we have out Parcel B. Lot 12 is 13 and a little bit extra of acres, and out Parcel B is 3.7 acres. So that's how we get to the 16.9. The current zoning classification is RMF 48. As you all are familiar with, in CB 13 of 2018 adopted a new zoning ordinance in Prince George's County, all new zoning classifications, but it could not become effective until all 300,000 properties in Prince George's County were placed in new zoning classifications pursuant to the adoption of a countywide map amendment, which occurred as a result of the adoption of CR 136. And that put this property in the RMF 48 zone. The RMF 48 zone is really, like it says, residential multifamily. That's the zoning classification it's in today, at 48 units to the acre. That's what's permitted of right in that zoning classification. There are also commercial uses permitted in that zoning classification. The prior zoning classification was MXT, mixed use transportation oriented. It was probably the most popular zoning classification to use in Prince George's County prior to the adoption of the new zoning ordinance. Its intent was to take properties at major intersections, put them in the zoning classification to encourage a diversity of uses, a diversity of densities, different types of residential uses, different types of commercial uses, to create a synergistic atmosphere that would include a 24-hour environment. That is really the purpose of the old MXT zoning classification. Now, Lot 12, and could you bring up slide 9? I thought that I was going to ask for slide 3, but when I saw slide 9 in your presentation, I thought it was very helpful. There we go. Okay, so you'll see at the top left, Maryland 210 Indian Head Highway, and running between those two purple-colored land masses, Maryland 228, which is Berry Road. Now, back in the day, all of what you see in purple was part of a conceptual site plan in the MXT zone, and all of it was zoned MXT. That rezoning occurred in 1993, I believe, at the adoption of the Subregion 5 Master Plan and Sectional Map Amendment. The council made a decision in that comprehensive rezoning to put all that property in the MXT zoning classification, all that purple-colored land area. So that in the MXT zone, you had to go through a conceptual site plan, a preliminary subdivision plan, a detailed site plan, and lastly, final plats of subdivision. Okay, that's because of the mix of uses and because it's a floating zoning classification, all those different layers of development approvals are required. A conceptual site plan was filed and approved by the planning board and by the county council for everything you see in purple on that map. Now, that occurred with a designation of Conceptual Site Plan 99050, which was considered and which was approved in July of 2000, after the adoption of the SMA. And what you see is in that conceptual site plan, there were three pods, three development pods. The curved area, that's purple, on the south side of Maryland 228 was Pod 1. That was approved for retail commercial uses. It is the site of the Manning Village Shopping Center, which is basically fully developed. There's a couple of pad sites left in there. The odd-shaped parcel on the north side of 228 in the southeast quadrant of the intersection of 210 and 228 was Pod 2. When Pod 2 was approved by the County Council and by the Planning Board, it was approved for up to 800 senior residential units to be included in a mix of residential types, clearly embodying the recommendations of the MXT zone. So they were to have single-family detached townhomes and multifamily buildings in Pod 2. Those were approved, up to 800. And then Lot 12, what you see now, sort of going southeast on the north side of 210, the triangular-shaped piece, that's Lot 12. And that was approved for retail commercial development. So that's what we had in the original conceptual site plan approval for the project known as Signature Club at Manning Village. 3 pods, 3 sets of development, very diverse types of residential uses, and a real key function on retail commercial. Because as you'll recall, one of the criticisms of the MXT zone was that people started using it primarily for residential development with just a smattering of commercial. This clearly embodies the real original intent of what the MXT zone was all about. Now, later, Pod 2 and Pod 3 went into foreclosure because the person who was the financial backer of the project unexpectedly passed away. A client of mine purchased Pod 2 and Pod 3. He also purchased a parcel known as Parcel 25. And Parcel 25 on that map is the sort of the clear area outlined in red between Pod 2 and Pod 3, right there. And the reason that Parcel 25 had been acquired is that access was denied on Indian Head Highway and access was denied on Berry Road. And they had to figure out how they were going to access the property. So they purchased Parcel 25 in order to provide that access, and that's the way it works today. There's a road called Caribbean Way, which provides access into the area known as Pod 2. Ultimately, Pod 2, after my client purchased it, was converted to fee simple uses. Instead of 800, 313. A smaller mix of single-family detached. The bulk of it was residential townhomes. And that project has been built, was not built by my client, it was built by someone who purchased it. My client originally, my original client still owns Lot 12 and part of what was known as Parcel 25. So as time progressed, and as the development was going to move forward, as I said, Parcel 25, which was going to be used for access, was rezoned to the MXT zone. But that was done pursuant to a zoning map amendment application. That was all of Parcel 25. Prior to the rezoning, the small triangular piece of Parcel 25, which is labeled on that map as Out Parcel B, as well as Lot 12, were joined together and made the subject of a preliminary subdivision plan. Okay? That preliminary subdivision plan was denoted as 4-01064. And when it was approved by this board, the approval was to develop 157,500 square feet of commercial development, retail, which would also include 10,000 square feet of office, okay? At the time that, and here's the nuance, at the time that preliminary plan was approved and platted, went to record plat, Lot 12 was zoned MXT, but what you see as out parcel B was not yet zoned MXT. It was still RR, and that's why it was designated as an out parcel. It was in water and sewer category 6, zoned RR, couldn't be developed with residential, with commercial, and it needed a category change. So it was platted as an out parcel, but it's part of the recorded subdivision for Lot 12 and out parcel B. After that, out parcel B and the balance of what was previously parcel 25 in that area outlined in red were all rezoned to the MXT zone. So what we have today is 2 pieces of property before you, both of which are zoned MXT, and both of which are the subject of a new conceptual site plan. Lot 12 had been part of the original conceptual site plan. Obviously, out parcel B was not. We determined that for purposes of consistency and for purposes of bringing forward the intent of the MXT zone, we wanted to develop this property using the prior zoning ordinance, which is expressly permitted in this instance by section 27-1704 of the new zoning ordinance and 27-1901 and 1903 of the new zoning ordinance. And I'm sure I'm going to be getting into that at a later stage. So what we did was we filed a new conceptual site plan. The old conceptual site plan had that number 99050. This case that's before you today, even though this is part of the overall Signature Club development, it's a new conceptual site plan, CSP 23002. A new number and a new process. That's why we're going through the conceptual site plan process here today to get that approval so that we can then file a new preliminary subdivision plan for just this section of Signature Club. So that's pretty much what we're doing here. Our proposal within this conceptual site plan is to have up to 300 multifamily units. Now, the density that would be allowed is substantially higher than that. My client could say, I'm going to build a monumental 6-story structure here and increase my density to what's allowed in the MXT zone pursuant to the floor area ratio, which is 1.4, which is an extremely high. No MXT project in Prince George's County has ever reached a 1.4 FAR. It's very, very high, very, very dense. But we could have gone vertical and put a lot more units in here. But we decided to use 8 buildings, and we said in our filing up to 5 stories. My proffer, and my client's here ready to testify today should you need it, but my proffer as his counsel is that those units are going to be a mix of 3- and 4-story units. We are not going to get to 300. We're going to be in the range of between 272 and 275 units total for the multifamily. No building will exceed 4 stories in height. There'll be a mix of 3-story buildings and 4-story buildings. Bear in mind, we have townhouses over there that are 3 stories right now. So that is our proposal under the conceptual site plan. To maintain some mix of commercial, we're proposing to retain out front along the Maryland 228 frontage 3 parcels for a total of 12,600 square feet of commercial development. We do not know what that might be at this point in time. It's going to have to go through the entitlement process, just like this property is going through the entitlement process today. But that will be a placeholder. It will be part of the preliminary subdivision plan that we file. We just don't have users for it right now. Wood Partners is the user. They are going to buy and construct these multifamily units on this property that is before you today. And they're going to bring a very attractive product to the marketplace, just as they have done every other location in Prince George's County where they have built and across the country. So that is our conceptual site plan submittal. That's what is before you today. We appreciate the staff's recommendation of approval with conditions. We appreciate the staff's understanding of the minor revisions that we made to 3 of the conditions. Well, we didn't really revise the first part of condition 2. It was more saying we don't want to put sidewalks certain places where they abut buffer areas. And one of those is to the north, where we abut a 10-acre piece of property owned by a gentleman by the name of Victor Christensen, who's here to testify today, in opposition, unfortunately, but we didn't want to put a sidewalk up against his property because he's concerned about people wandering over into his land area. So that's why we didn't want to put a sidewalk up there, but there will be more about that. At this point, I'm going to stop. This is an overview of where we are, that this is an overall, Signature Club is an overall mixed-use development approved for high intensity. What we're doing, we think, is complementary and compatible with the MXT zone, with other MXT projects that have been developed in the county. And I'm going to sit down and I'm going to see what I have to come up and rebut during my rebuttal case after everyone else testifies. So thank you very much. I do have witnesses that I'll call on rebuttal, and I'll be up here sometime in the future today. Thank you.
I appreciate your testimony, Mr. Gibbs. Are there any questions from the planning board?
I just have one. What's the reluctance to go higher than 4 or 5? And the reason I ask for, because in that sense, you can maintain more of the trees, et cetera.
Well, I guess everything's always a balancing act. You know, the testimony you're going to hear from most of the folks in opposition, because I've talked to a lot of them. You know, we did our normal community outreach. I mean, we reached out to the Ackeek Development Review District Commission, the HOA for Pod 2, who are, many of whom are in opposition to this, and then some adjoining property owners like Mr. Christensen, who, all of them, I respect their opinions, but they would say that the higher the building, the worse the intrusion is for them. I think they would say that, because that's one of the concerns when we were at a highest level of 5 stories. It was, oh my gosh, you're going to have 5 stories. That's what I'm going to have to look at. So my client's approach in proposing a development plan was to implement the intent of the MXT zone while at the same time making it compatible with other uses in the area. And that can be done with multifamily. And he, quite frankly, Wood Partners was just trying to do the best it could to bring its product to the marketplace while at the same time not creating an imposing structure that folks would not want to look out at every day.
Thank you.
Any other questions?
None here.
Thank you.
I'm now going to ask for the public to come up and speak, and I have a list of those that are.
Sorry, so those signed up in advance, and those signed up in person today. So we can start with those that signed up in advance.
Those that are coming up to speak, I'm asking you, you have 3 minutes to speak, and we're going to start with, I apologize in advance if I mess up your name, Mr. Hillard, Jaquan Hillard.
Is he online? Is he virtual?
No. We're going to go to Alex Votel.
She's online.
Hi, good afternoon. May I respectfully request 5 minutes instead of 3 minutes, since I am an attorney representing citizens and the applicant's attorney got, I think, 15 to 20 minutes.
Yes, ma'am.
Thank you so much. I really appreciate it, sir, and welcome to the board. I'm excited.
As a point
to have
of
you.
order, I'd like to ask Ms. Votar if she took the oath. I did not see her hand come up.
My understanding is that if Mr. Gibbs took the oath, my understanding is that attorneys are not supposed to take the oath, that's inappropriate. I'm happy to do so. My testimony is truthful, but my understanding is common practice is attorneys do not take the oath. They present argument on facts that they have to present via evidence.
Ms.
But I'm
Votel,
happy to do so.
go ahead and proceed.
Okay, thank you, sir. So for the record, my name is Alex Votaw from the Law Office of G. Macy Nelson. Today, I have the pleasure of representing Carolyn Keenan and Jordan Ebers. I believe they're also there and plan to speak briefly after me. We've submitted written arguments outlining some of our very serious concerns with this application. I hope the board has opportunity or has already had the opportunity to review those. They're in the additional backup. So instead of going through each one of those, I think we've adequately covered them in our writing, and to respect the board's time, I just want to highlight some of the key issues. So starting with the conceptual site plan in this case, the transitional provisions describe that when you're relying on prior development approvals and you're applying for a conceptual site plan, you can't combine two properties that were subject to separate approvals. And what we see in, I believe it was slide 8, the one before the slide that's currently showing, is that lot 12 was subject to a separate CSP than out parcel B, which is the northern lot. Those should not be combined. And if they are combined into a new application, as is being requested here, we believe that's not allowed. But even if it is, then they should not be allowed to rely on a previous tree conservation plan as well. So you either have new CSP and a new tree conservation plan, or you can have reliance on a previous CSP with only the properties covered by that previous CSP, and you can rely on that previous tree conservation plan. You can't have it both ways, is the issue here. So for that reason, we believe you should deny this application. I want to touch briefly on two substantive points on the CSP. That's first and foremost, staff found that there's not adequate traffic capacity at least one intersection in this application. That's clearly stated in the traffic report. For that reason alone, this application must be denied. The requirements of the law require a finding of traffic adequacy at this stage, not at the preliminary plan stage. And we're going to have an expert, Larry Green. He has signed up to testify. He will touch on this as well. The other issue is the compatibility. Staff and the applicant have argued this is more compatible with the area, but the area does not have any structures that are 5 stories, especially structures that take up the entire site that are 5 stories. The evidence we've submitted on to the board in our exhibits demonstrates that the area around this property is at most 3 stories. So we believe this application should either be denied on that grounds or limited to only 3 stories high to be compatible with the surrounding area. And then I want to touch on the tree conservation plan because I think that's really important here. First, I unfortunately have to vehemently object to the proposed amendment to the staff report, where the staff proposes to remove the fact that the prior approvals were not complied with and the applicant or the property owners have failed to provide at least 7 acres of woodland conservation that was previously required. That should remain in the staff report. It's important context for this board to consider. We object to that change. And the last thing I want to focus on is the forest retention areas that are on this site. This site, according to PG Atlas, according to picture signs on the property itself, and it seems to be implied by previous approvals in this case, has forest retention areas on it. The applicant has to demonstrate how it is allowed to remove those forest retention areas that are already located on this site. That's a really big issue. And respectfully, the applicant has to provide actual evidence explaining how it is allowed to remove these forest retention areas and what it's going to do to make up for their removal. The applicant has not done that. They have not addressed that. And again, respectfully, I don't believe opposing counsel can address that because attorneys, as I said, are not providing testimony. We provide argument. We explain the evidence we are presenting to the board. The applicant has to provide actual evidence from a witness or via documents demonstrating and accounting for these forest retention areas, because this county is essentially hemorrhaging woodland across the county, and that's causing substantial woodland. It causes health issues. It causes environmental issues. So I really urge this board to take that issue very seriously and make sure the applicant is complying with all of the requirements of the conceptual site plan and particularly the tree conservation plan in this case, because they are proposing to exclusively meet their requirements off-site through off-site mitigation. And in the past, that has not been complied with after the approval. So I really appreciate your time. Thank you so much, Chairman, and welcome to the board.
Thank you so much. Asia, I can't pronounce your last name. Bowman Shedder? No. Brittany Braswell,
Hi, I'm here.
thank you.
I just want to address a few things, starting with the website for the PG Planning Board, which says that your mission created in the year that it was created is created to improve the quality of life for PG residents. So nothing in that mission brought up WP Acquisition and other developers and the quality of their business. It's focused on the quality of life. And when we look at projects like this, the people who live in the areas that projects like this pop up in, their quality of life is directly affected in a negative way, from air quality to the quality of the schools that are already busting at the seams. Wynn Park, I was a teacher at Wynn Park for many years. I had 40 plus students in my class. To the roads, 210 is one of the deadliest highways in Maryland. I get anxiety when I get on that highway. I'm checking my mirrors 3-4 times on that highway. So I just wanted to say that and bring that up to just remind the board that we expect you guys to advocate for the quality of our lives, not for developers. And that's all I would like to say. Have a great day.
Thank you so much. Gassie Tiklu,
Good morning. My name is Sam. What? What?
There you go. You got it.
Okay. Good morning. My name is Gadisa and I'm 8 years old. I go to Akikiki Academy and I learned that you might let people cut down a forest to build apartments. Please don't. It's crazy. First of all, our elders, children, and adults with asthma suffer greatly, and so are people with ADHD and people with no conditions. They would all have to breathe low-quality air because trees take in carbon dioxide and turn it into oxygen. So by cutting down trees, it's like you're purposely making the air worse. I love our forest so much. Akakik is naturally beautiful. By taking away the forest, you are also getting rid of the animals that live there. Animals like birds and foxes keep the bug population down. Bees, butterflies, and beetles all are a major part of the ecosystem. Beetles break down materials that make the land nutritious. Butterflies and bees pollinate flowers and plants, which help them grow. Also, it's a home to lightning bugs. I know people need places to live, but why cut down the forest? Isn't there open land in Prince George's County without trees where you could build houses? I'm afraid and sad about climate change. When I grow up, I have to deal with climate change. You're already grown up, so you won't worry about it as much as me. This is why we need to keep our forests and swamps. They help protect us from getting too hot and from flooding. Texas is flooding right now. I don't want that to happen to me or the community. Please don't let them cut down our forests. Find another place without trees. Keep our forests safe for me and all the kids who want to stop climate change and protect the habitats of non-humans. Humans need to learn how to live peacefully with other species too. Thank you for listening. Sincerely, Gidise, Akakik Academy student.
Thank you. Thank you.
Gassie, I want to just say that you did an outstanding job. I don't know what the outcome is going to be, but I applaud you for advocating for yourself and your community. And we need more young people like you in this world, so great job.
Indeed.
Julian Dodson.
Hard to follow up, could you say? She's my neighbor. I appreciate you for doing that. I'm also a teacher, as the previous speaker mentioned. And I have a few notes here. So I live around the corner from this beautiful forest, and I've lived there for nearly a decade. I've raised my children there. And then this patch of forest is not just a patch of forest. It's not just 4 specimen trees. It's a part of our family's story. It's who we are, and it's what we talk about when we talk about Prince George's so beautiful and gorgeous Prince George's. Do these developers live in Accokeek? Do they even live in Prince George's County? Do they live in Maryland? Do they live around the corner from the 300 units that are crammed into 8 buildings, or nearly 300 units, tucked behind a cloak of beautiful trees on a quiet street? Would they allow their project to go forward if their mama lived there? I don't know. Every year, this forest removes 33.8 tons of carbon dioxide, like Gadise spoke about. Filters 456 pounds of air pollution that could otherwise settle in their lungs. It absorbs millions of gallons of rainwater that shields our area. If you notice, one of those site plans showed a downward slope to our little creek where our kids go and play sometimes. That creek will be gone because of the amount of storm runoff and sewage runoff. Similar to across the street where those folks are complaining right now about sewage and its stench when the kids play basketball. This forest will erase the beauty that we have there. It means the elderly will breathe in terrible air and just listen to the bulldozers that are making all the noise instead of the birds chirping. These garden pollinators and different animals that we see would just seek homes other places. The mice would seek homes in my house. And when those mice start running from the bulldozers, no one wants mice. That's all I gotta say. No one wants mice. This isn't about the trees. It's about our lungs and how our neighborhood breathes. The old staff report and all the old things were approved a while ago. 2000. I don't know who was on the board at that time and what was looked at that time, but I came long after that. Even when I got there, there were new developments being built, and those things were thrown up fast. So all the preliminary planning might be there, but when they start building, they want it up fast so they can get money in their pockets fast. This process here is definitely rushed. It's hidden.
Your time is up, if you want to conclude.
Okay. Let me get to the last little section. I would say that the forest can't speak for itself, but I'll speak for the forest.
Thank you.
Thank you.
Ms. Karen Thomas. Karen
Good
Thomas.
morning. Good morning. I'm here.
All right.
Hi.
You have 3 minutes.
My name is Karen Thomas, and I live behind the proposed development on Bill Hill Forest Lane in Accokeek. My husband and I bought our home a little over 3 years ago because it was in a good neighborhood in an area filled with single-family homes, old and new. My community is filled with residents who have worked hard and moved here because it was quiet and peaceful. Now we find out about this plan. I took the time to read the 200-page document outlining the history of this development, which goes all the way back to the late 90s, early 2000s, when this community was very different. I don't think anybody's taking into account the changes that have been made in the last 20 years. The statement to encourage diverse land uses which blend together harmoniously is definitely not being upheld by this development. I don't know how a 300-unit apartment complex will blend together harmoniously in a community of owned single-family homes and townhomes. It will only serve to diminish them. Additionally, this will increase traffic in an area that is already traffic heavy. The traffic circle that is mentioned throughout that 200-page document can barely handle the communities it currently serves. And we're already adding 218 townhomes and 95 additional single-family homes to this area. The congestion from Manning to Dusty, Mink, and other back roads can be significant already on days where there are backups on 228 and 210, because everybody that knows to use these back roads. Not to mention GPS will divert traffic this way when there are traffic issues. This is not a walkable area, as the application and conceptual site plan mentions. Going across Berry Road is dangerous in a car. People run those lights all day, every day. There is really rarely a day there's not an accident at or near this intersection. It would be dangerous and negligent to propose any residential any resident walk across those streets. The conceptual idea that this would be a lifestyle center feel is impossible. There is no way 12,000 square feet of retail will be meaningful. No national retailer would take that small of a space. All we would get is more of the same, more liquor stores, more vape stores, more small soul food spaces. We don't need those. We need meaningful retail. And how do I know this? Because I lease space at a shopping center, which is where I am today. So we're not adding anything to this community. We're taking away from it. We're devaluing it. We're devaluing the home prices of the residents that already live here. I hope we can reevaluate this plan. Thank you.
Thank you. I think it's Corinne Eba. I say that correct? Last name is E-B-A-H.
Yeah.
Right here. He's on. It's around one, but. Eba. We're gonna move on. Lawrence Green.
Yes, I'm here.
You have 3 minutes.
Good morning. My name is Larry Green. I'm a registered professional engineer in the state of Maryland, as well as a nationally certified professional traffic operations engineer. Your Honors, I only have 2 points to raise. Number one, I agree with the staff findings that the proposed Signature Club East development will exceed the trip cap of 147 AM peak hour and 524 PM peak hour trips. The applicant has presented an argument that if internal trip reductions and pass-by trip reductions are included, then the Signature Club East development will only exceed the trip cap during the AM peak hour. Based upon my review of preliminary plan of subdivision 4-01064, there are no stipulations for assumed reductions of internal trips or pass-by trips. The condition only establishes a trip cap of the number of trips generated by the development. In this case, the trip cap is exceeded during both the AM and PM peak hours. Point two, the applicant has raised an argument that the proposed Signature Club East development, with the inclusion of internal trip captures and pass-by rates, will impact the Maryland 210 at Maryland 373 intersection by 16 critical lane volume units less during the most critical PM peak hour as compared to the previously approved development application. Based on park and planning traffic impact study guidelines, for intersections which exceed the level of service D criteria or a CLV above 1450, recommendations must mitigate the site traffic impact by 150% at these negatively impacted intersections. Therefore, since the new development plan was shown to reduce the critical lane volume by 16 CLV units at the Maryland 210 at Maryland 373 intersection during the PM peak hour, then in order for this plan to be deemed an acceptable mitigation measure, then the original traffic impact to the Maryland 210 and Maryland 373 intersection by the previous development must be 10 CLV units or less, because 150% of 10 is 15, which would be less than 16 CLV impact. Based upon the previous plan submission, it is inconceivable that the previous development proposal had an impact to the Maryland 210 and Maryland 373 intersection of 10 CLVs or less during the PM peak hour. Therefore, the simple change in development plan fails to meet the park and planning traffic mitigation guidelines. Thank you very much for your time.
Thank you. Lisa Berman.
Good morning. I'm Lisa Burnham, a resident of Accokeek, and I'm very concerned about the proposed development at Manning and Berry Road. Putting 300 units on 16.9 acres is way too much for our area. This goes against the county's climate action plan. Also, the developer's track record is poor. Nearly 100 Signature Club residents are suing Ryan Homes and Caruso Homes right now for property damage, sewage backup, and awful smells from badly designed wastewater systems. These developers knew the systems were poorly installed but didn't warn buyers. Since 2021, these residents have been getting overcharged for wastewater. Their home values have dropped and their insurance went up. As usual, these developers put profits over people. We don't want more of this in Accokeek. The forest area soaks up nearly 500,000 gallons of rainwater every year. Without it, we'll see increased flooding for nearby properties and higher insurance costs. Without these trees, temperatures will rise 5 to 9 degrees, making higher SMECO bills, stressing our power grid, and real health concerns from the heat. Our local wildlife will suffer and be displaced. Our pollinators like bees and butterflies will be endangered. Once we lose these natural resources, we can't get it back. Traffic, as many people have already said, 10 is really dangerous. Adding 300 units means at least 600 more cars on an already congested road. This means more accidents, longer commutes, and more crowded schools. Accokeek Academy, where my daughter attends, is already at capacity. The new Fort Washington school helped, but didn't solve the overcrowding problem. Adding hundreds more children will further stress teachers, increase class sizes, and impact the quality of education for all our kids. We need to build infrastructure that can support adding more families to this area. Instead of high-density development in environmentally sensitive areas, we should encourage northern PG to make more affordable housing so it's easier for people to live closer to their jobs. We need to reduce sprawl and long commutes, make recommendations that honor the climate action plan of our county, invest in public transportation to reduce car dependency. Even without signatures, we're already dealing with overcrowded schools, difficult commutes, and unsafe roads. Accokeek is one of the few places left in PG with sprawling green spaces. Wetlands, forests, wildlife that give character to this area are irreplaceable, and we know that developers don't care about that. These are irreplaceable resources that benefit everyone, and it's not an invitation to developers. We want development that serves our community's long-term interests. Signature Club East will strengthen our infrastructure and improve natural resources that protect us from flooding and extreme heat. I respectfully ask you to reject this proposal. District 9, Accokeek needs more schools, walkable roads, public transit, and protection of natural areas to keep us green, healthy, and in a sustainable community. Thank you for your time and consideration.
Thank you. Megan Krieger. Megan Krieger. Raina Dotson.
Morning. Thank you so much for this hearing and for hearing our testimonies in opposition. My name is Raina Dotson. I'm from this community. I live in Accokeek. We've been here, raised our 3 kids for the last decade in this community. This plan to destroy almost 17 acres of mature forest for about 300 apartment units it's not just ill-advised, it's potentially illegal, unsafe, and based on false confidence in a developer who's already failed this community. First, the proposal potentially violates Maryland's Forest Conservation Act. The developer hasn't shown that the forest clearing is the minimum necessary, nor have they prioritized on-site retention as legally required. Second, let's talk about trust. Signature 2016 Residential LLC is currently being sued by residents, as has been mentioned by my neighbors, of their existing Signature Club development just across the street. Since 2021, those residents have endured repeated sewage backups into their homes, flooded basements, and noxious odors. Gross. Complaints have gone unaddressed or have been slow to be addressed. Promises have been broken, and the company's pattern of neglect is well documented in court records, in court filings where I saw them. These are not hypothetical risks. They're ongoing harms right now affecting real people who were assured their homes will be safe. This is the same developer asking you for permission to build 300 more units. Why should the public or this board believe they will suddenly operate differently? Third, this proposal violates adequate public facilities ordinance. Our local K-8 school, Accokeek Academy, where my kids matriculated, is overcrowded. The recently built Fort Washington School, as has been mentioned, hasn't resolved the issue. The development will only make matters worse, placing additional strain on classrooms, teachers, and students. Fourth, consider the impact on public safety. As has been mentioned, we all know Maryland Route 210 is a death trap already. It's already among the most dangerous highways on the state, and adding over 600 more daily vehicle trips without roadway improvements is reckless and will increase the risk of serious accidents, including to my two teenage drivers who are on 210 almost every day. Fifth, removing almost 17 acres of forest, as has been mentioned, will harm the environment, which directly impacts us in Little Giddese. Staff recommends approval with conditions, but what conditions could possibly replace mature forest? There's mention of indefinite waiver in the paperwork. Waiving what exactly? Where's the environmental impact statement? Where's the analysis of cumulative impact from nearby developments? This board faces a simple but serious choice. You can stand with us, the residents, protect public health and safety, and uphold environmental laws by denying this application, or you can enable a known violator with an active lawsuit to destroy forests and worsen flooding, traffic, and overcrowded schools. At minimum, I urge you to defer this decision until a full environmental review is completed, viable lower impact alternatives are considered, and the public has adequate time to assess this plan. Forest cannot speak, as been stated by my husband, but we can and we must speak for it. Please deny this dangerous and irresponsible proposal. Thank you.
Thank you. Titiana Gomez Ramirez.
Morning, members of the Prince John County. My name is Tatiana Gomez. I am proud resident of Accokeek. I'm a member of the Network Club community.
Can you get a little closer to the microphone, please? Thank you.
Closer. You're fine.
Okay. Today I stand before you, not just as an individual, but as a voice of the many families who have signed a petition and strong opposition to the proposed development of Lot 12 and of Parcel B. This proposal, which includes 100 multifamily dwelling units and over 12 square feet commercial space, poses a serious and irreversible threat to integrity of our community. First, let me speak to the environmental impact. This development will wipe out on our area's last remaining forest ecosystems. It's home to native wildlife and plays a vital role in purifying our air, regulating temperatures, absorbing stormwater, and replenishing groundwater. Once it's gone forever. The environment cost is too high, especially at the time when we should be protecting, not destroying our natural resources. Second is this example for overdevelopment without responsible planning. Accokeek is a semi-rural community. That identity is important to us, and is why many of us choose to live here. Adding 3 high-density units and new commercial buildings will be put an unsustainable burden in our schools, utilities, emergency service, and recreational space. The infrastructure simply isn't there to support this kind of development, and there is no clear plan for how those gaps will be addressed. Third, traffic and road safety. Anyone who lives in Accokeek knows that Route 2010 and Livingston Road are already experiencing congestion. This development will dramatically increase traffic on narrow residential roads, schools, bus roads, and already congested intersections. This is not just inconvenient, it's dangerous. Emergency response times will be delayed, and accidental risks will increase, especially for children waiting at bus stops. 4, and perhaps most personal to many of us, are the safety and liability concerns. With higher population density and new retail space often comes increased crime, robbery, vandalism, and loitering. Accokeek currently does not have the law enforcement resources to handle such in population and activity. We worry about what this means for our peace of mind, for our children playing outside, and for our community quality of life. In conclusion, we are not anti-growth, we are anti-pro-responsibility. We support development.
Your time is up. You want to conclude?
Yes. We urging to the planning board to listen to the residents who live every day. Please reject this proposal and instead work with us, creating a better, more sustainable plan for Accokeek future.
Thank you.
Thank you.
Thank you.
Victor Christensen.
I read the planning report, and there was one item in the planning report that I want to bring up. It basically said that there were no comments from the community. This is very misleading. I don't.
Could we have you identify yourself again, please, sir?
Victor Christensen.
Your address.
16521 Boot Hill Road, Accokeek, Maryland.
Thank you.
I was saying that the report states that there was no response from the community. The community, this implies that the community doesn't care, or that the community agrees with the project. This is simply not true. I spoke to a few of my neighbors, and they were shocked and outraged when they heard about the massive project that was being proposed. Recently, a petition has begun to circulate just within the past few days. It's gotten over 300 signatures. So the community is opposed to this, and they do want to comment. I don't understand why there was some disconnect, but the community hasn't had a chance to comment. I suspect that over the next few weeks, hundreds of thousands, even more people will comment and be opposed to this project. They just haven't heard about it. And I don't think that's right. The people have a right to speak. They have the right to have their opinions heard. And to date, I don't think that has happened. Several people have mentioned Interstate 210. As you probably know, just last week, a week ago today, there were 2 fatal accidents on 210. 3 individuals died. This is not unusual for 210. Safety advocates have named 210 the highway of death. The AAA has said repeatedly, year after year, that it's the worst highway in the state of Maryland and probably one of the worst highways in the entire country. We need to address that problem, and the solution is not by adding more congestion and more traffic. The report stated that one intersection will fail. That should be enough to say that this should not happen at this time. The solution is to fix the road, not add more congestion. It would just make it worse. It would just cause more disruption, more death. Thousands of people use that highway, and they would be in traffic jams, more road rage, more accidents. That's not the solution. The solution is to fix the highway. And there were several proposals to fix the highway since I've been there. They wanted to put overpasses on Route 210. That money was taken to fund the Purple Line, I understand. 1 overpass was put in, but that's not sufficient. The other 7 were never put in. The intersection between 210 and 228 is a malfunctioning disaster. That was supposed to be flyovers. When they put that in, they said, oh, it's only temporary. We're putting in flyovers, so there wouldn't be any lights there. That was like
Mr. Christian,
years ago.
your time is up. Would you like to conclude?
Yes, I would like to conclude just by finishing saying, this is an unmitigated disaster. It's just waiting to happen, particularly in terms of 210 and the congestion that it would cause. Thank you.
Thank you.
Khalid Dodson. Caleb.
Good morning. My name is Caleb Dawson. I've lived in this community for half of my life. A forest is not just beautiful, it's protective. It cleans the air we breathe. It cools the streets we ride our bikes on. It absorbs the stormwater that could otherwise flood our basements. Every year, it removes 33.8 tons of CO2 from the air. It filters 456 pounds of air pollution. It absorbs nearly 500,000 gallons of rainwater. It shelters pollinators, birds, and native wildlife. Now, developers want to bulldoze it all and turn it into just pavement and profit. Let's be honest. They would never approve this next to their homes. They wouldn't want it near their children. They wouldn't dare put it next to their mother's house, but they will do it to ours because they do not value our neighborhood. And to them, our neighborhood is expendable. That is selfish and that is wrong. And it's exactly what's happening here. The consequences are real. Destroying this forest will raise local temperatures by 5 to 9 degrees. It's already like 100 degrees in my neighborhood. I was just out the other day. It's too hot. We can't have it raising even more. Where will children go to play? They're going to be crammed into their houses. It increases flooding in neighborhoods that are already struggling, and it displaces the same wildlife that keeps our ecosystems balanced. It contradicts the Prince George's County's own climate action plan. Furthermore, a lot of other people talked about Academic Academy and the amount of the overcapacity. I went to that school. The hallways are already extremely crowded, and it's already overcapacity. We don't need 300 more units and even more children crammed into that school. So I have to ask, what sort of leadership is this? The county tells us that they care about the environment. You tell us that climate is a priority. But when the time comes to make real choices, they hand out approvals like candy. Stamp yes on the developer's wish list and tell the community we should be grateful for the conditions. But I ask you, what condition can possibly replace 16.9 acres of forest? There's no replacement. There's no replanting plan, no stormwater system, and no landscape median that can match what the living forest already does for free. The whole process reeks. An indefinite waiver? Waiving what? Environmental protections? Oversight? Public accountability? And where's the environmental impact statement? Where's the cumulative analysis, especially when other developments are going around us? The truth is, they don't want to look at the full picture, because if they did, they could not justify this. In the staff report, it recommends approval with conditions. That's a rubber stamp dressed in bureaucracy. I have a petition here with around 300 signatures in opposition of this project. They say they talked to our community, and what did they get in response? They did not talk to us. I have here proof that 300 people don't want it in our community. It's our community, and we should have say in what happens in our community. So you have the opportunity today to do what the community needs and actually stand for our community and stand for what our county is supposed to stand for. Thank you.
Thank you.
Robin Braswell.
Good morning. I'm Robin Braswell. I'm a community member of Signature Club. I built my house last year, July 2024. In the middle of that process, I was asked to sign a document informing me that they were being sued by the residents of that community because the property, the water's bad. WSC will not touch us. We have pumps in our yards that try to do something to pump out the water.
There's a stench in that neighborhood because of the sewage system. Currently, they're building 140 townhomes right in front of the community. I ride 210 every morning. It takes me no less than 30 minutes to go 10 miles. We already heard that AAA calls it the deadliest highway in Maryland. It is ridiculous, the amount of traffic and the speeding that occurs already on that highway. So we're talking about another 140 residents being built currently right outside our community in that section above. So that's a potential of 280 drivers. Then we want to add another 300 across the road, potential of 600 plus drivers on a road that cannot handle already the people who are coming down it on a daily basis. My daughter, Brittany Brazel, spoke earlier. She built her house across the street from me. I was supposed to age in place there. I don't think I'm going to stay. I moved from Accokeek not too long ago, 5 years ago, to this part of Accokeek. I might have to move again because this is ridiculous. The time it takes, that highway cannot handle the traffic. And to put 300 apartment units there, that's ridiculous. Let me see what else I had in my point. And then they talked about commercial establishments. So you were talking about even more traffic coming there. We have commercial establishments across the street. We have Giant. We have 2 banks. We have 7-Eleven. We have a gas station. We have commercial establishments there. We don't need more. That's even more traffic in an area that's already overpopulated. This does not make sense. I hope you support the residents and stand by us. We have to live there. These developers don't live there. They don't care. They don't give us anything. When I signed my contract, my HOA was $140. By the time I went to closing, it's $168. Why? Because the water is bad, and we have to pay another company to manage our water. We have to pay another company $400,000 a year to manage our water. That shouldn't have been approved back then. That the land is bad, that the water is bad, homes are being flooded, sewage is backing up. That's a problem. What is that going to do to our community? Thank you.
Thank you. There were 3 people that were in favor of this project. We'll start with Mark Ferguson.
Very briefly.
Yes.
My clients, I believe, this is Alex Votok for the record.
What's your name?
Alex Votok. Alex Votok. I'm the attorney for Carolyn Keenan and Jordan Ebers. They have not been called. I believe they're signed up to testify. I understand that the new rules apparently state that if persons are represented by attorneys, they can't testify. But the new rules also say I was entitled to a full case in opposition. I was not given that opportunity. I instead would like to request that the board give my clients their 3 minutes to say what they want to say.
Not at this
time.
Let people speak. This is our community. Don't let rules like your random rules suppress the voice of people who will be impacted by this. This developer, he represents a developer. He's going to get all the time he wants to speak. Give us 3 minutes. What do you do?
I'm going to ask you all to follow the rules that we have in place.
To suppress the voice of people.
Listen, ma'am.
Your civic duty to speak up. You say that we don't care about our community, and when we show up, we take their voice away.
I'm going to say this one more time, or I'm going to ask you to leave. Please let me allow for us to follow the rules and procedures. We are going to make a decision that makes sense, and I'm going to follow that. So is Michael Lenhart here?
Yeah, Mr. Chairman, all 3 of those witnesses are part of my team, and so they would be part of our rebuttal case.
Fair enough.
Then, just for the record, I would like to object to this proceeding, but I'll drop the point. I just want to make the record clear. Thank you so much.
Yes, ma'am. Is Michael here?
Mr. Chairman, thank you very much. So are we at a point where we can go forward with our rebuttal now?
Yes, you are.
Oh, okay, great. Thank you very much. First, I would like to respond to the first objection that was lodged by counsel for 2 of the residents. Alex Votok spoke at the commencement of your taking testimony. I want to address the first issue that she raised. Then I am going to call witnesses. I'm going to call Mr. Michael Lenhart to address and rebut transportation testimony that was made. And I am going to then call Mr. Mark Ferguson, who is our land planner, and he is going to address a number of issues, most substantially the woodland issues that have been prevalently mentioned in opposition testimony. I do have a question, though, and that is, it had been my understanding that staff of the Natural Resources Division was present and they were going to respond to comments about tree preservation. Is that true?
Yeah,
Normally, that would happen before I do my rebuttal, but whatever the wish of the chair.
I want you to go ahead and continue.
Okay, sure. So let me first address the comment that counsel for two of the opponents in this case mentioned during her remarks, called as the first person to speak. And that is the assertion being made that there's a violation occurring here by virtue of having lot 12 and then adding a part of an additional piece to it, meaning out parcel B, and still using the prior zoning ordinance. The section that Ms. Votaw is referring to is section 27-1704A. And there is a prohibition to adding land area to a prior application and including it as an ability to apply use of the prior zoning ordinance, meaning the MXT zone versus the RMF 48 zone. That would be true if we were using the original approved conceptual site plan that included the three different pods of Signature Club. That is not what occurred here. And we made that very clear in our justification statement that we were filing a new conceptual site plan here. It's a new conceptual site plan. It includes lot 12 and it also includes out parcel B, but it is a new application and it is not subject to the prohibition that Ms. Votaw referred to. Further, there is an additional issue that is applicable, and that is, we're relying on section 27-1704 of the new zoning ordinance to allow us to move forward the manner that we have chosen to do so. But there is also another applicable provision, and that is section 27-1901 and 1903. And 27-1903B specifically says that except as otherwise provided in this section, development applications of any type for properties in all other zones of the county may utilize the prior zoning ordinance for development of the subject property as long as you fall within the time frame set forth in section 27-1901, and that is 3 years from the effective date of the ordinance. So this application was filed within 3 years from the effective date of the ordinance. So there is carte blanche right in this section to do what we have done, and we are not prohibited, as Ms. Votaw has made an allegation in her article. So with that being said, I do want to call next Mr. Michael Lenhart. He is our transportation expert. Mr. Lenhart has been qualified as an expert in the field of transportation planning and engineering on many, many occasions before the board. I'm happy to have him go through his qualifications, but because he's been accepted as an expert on many occasions, I would offer him as an expert today.
Thank you. Mr. Lenhart.
Mr. Chairman, I'm going to object. I believe the rules say that prior to providing testimony, this is Alex Votaw for the record again, sorry. Prior to providing testimony, individuals offered as an expert witness must provide written evidence to the board of the individual's expertise.
He has been here before, so we'll accept his testimony.
I'm going to object to not following the rules of procedure, but I'll drop it so we don't have to waste time. Thank you.
Thank you. Yeah. You may proceed.
Good morning, thank you. So I just want to confirm, as a rebuttal, I'm not limited to the 3-minute rule, right?
That's correct.
I think I'll be within that, but I'll try to be brief.
I hope so.
The purpose of my testimony is to provide information related to the transportation adequacy issue. It's our opinion that mitigation is not necessary, and this property has an approved trip cap and an existing certificate of adequacy that will result in a credit of that capacity in the new certificate of adequacy that's issued at the time of the forthcoming preliminary plan. This existing property has a previous approval, preliminary plan 4-01 064. Condition 3 of that resolution states that the total development within the subject property shall be limited to 157,000 square feet of retail and office or different uses allowed under the governing CSP, which generate no more than 147 a.m. and 524 p.m. peak hour trips. This application, as it exists in the CSP and the forthcoming preliminary plan, does exceed the morning peak hour trip cap, but it is within the evening peak hour cap. The Transportation Review Guidelines states that a background development is an approved and unbuilt development within the study area, having an approved and valid preliminary plan of subdivision or a valid final plat. This property has both. Furthermore, the property received an automatic certificate of adequacy on April 1st of 2022 with the prior trip cap and associated transportation improvements, and that ADQ is still valid. The total traffic conditions in this traffic study will operate better in the background traffic conditions during the evening peak hour than it will operate under the background conditions, meaning that the approval of this project will result in an improvement in the levels of service at Maryland 210 and Maryland 373 than what would be expected if the property would develop using the existing approvals. Not only does the current proposal not have a negative impact, the approval of this current proposal would have a positive impact as it relates to the levels of service at Maryland 210 and Maryland 373 when compared to the current approvals. This property has vested rights under 24-4503E1 in that all of the required dedication and improvements have been constructed. Per 24-4503C1C, the exhaust let me jump to the mitigation. This will require an ADQ amendment at the time of preliminary plan to incorporate the changes in the transportation capacity as discussed in 24-4503G. In summary, we do not believe that mitigation is going to be required here. However, if at the time of preliminary plan, it's determined that mitigation is required, we have identified potential mitigation at 210 and 373. That involves split phasing the traffic signal and restriping the minor streets. So the west leg would be one left turn lane, one shared through left, and one right, shared through right. The east leg would be one left turn lane, one shared through left, and one free right. That improvement mitigates 300% of the site's impact. The Transportation Review Guidelines requires only 150% mitigation. This would mitigate 300%. Again, we don't believe that's necessary, but mitigation is available and has been identified if required at the time of preliminary plan. I'd like to address a few comments by Mr. Green. He testified that pass-by trips and internal trips should be included in the trip cap and not reduced out of the trip cap. That is not in conformance with how this has been treated historically and not in conformance with what is in the guidelines. The guidelines identifies pass-by trips and internal trips that can be applied. It gives guidance for how to apply that. And pass-by trips are trips that are already on the road network. Internal trips are trips that are between uses on the site and never hit the road network. These are not included in the trip cap, and they have never been included in the trip cap. So that comment was inaccurate. I also made some comments about mitigation at 210 and 373. Again, we don't think it's required. If it is required, we have identified, as testified, potential mitigation improvement that would mitigate our impact and provide adequacy per 24-4505.
I just have one question. as I'm listening to those that are opposing and forgive me, this is my first day on the job. But what concerns me is just the fact of what I'm hearing and what I know that 210 is the deadliest highway, I would say, in America. And it was one of those things that I worked on extensively when I was a state delegate. So I'm more concerned with the conversations that you guys have had with the community as it relates to your mitigation plans and other ideas to try to soften that blow, if you will. Right. So if you can expound on that, that would really help me understand the traffic issues that they're raising that is of concern to them as well as to me.
Certainly. So adequacy of transportation facilities. So the safety aspect is a valid concern. That's a real issue and not to be downplayed. And I don't mean to sound that way, but adequacy of transportation deals with congestion and capacity related issues. There are measures in the guidelines and in the subdivision regulations that specify how adequacy is to be measured. And it generally involves capacity related issues. And again, I would say this project, it's already an approved background development. They could develop today if they wanted to develop 157,000 square foot shopping center. They would need no further adequacy testing or approvals for that.
Let me, and I get the part that they could do it. I'm clear. Yeah. But the part that I always going to have a problem with, and I think this is for any other land use attorney that comes before this board, is that there needs to be a better or more inclusive conversation with the community on how we're rolling out these projects. Mm-hmm. I just think that if we have those conversations ahead of time and try to mitigate some of the issues ahead of time, I would not have 15, 17 people testifying in opposition. I think as a subject matter expert when it comes to transportation is to really try to work with the community on those mitigation plans. And I think as we continue to go forward, that's what I would like to see, a more broader conversation on how we're working more collaboratively with the community. And what are those community benefit agreements that they now feel most comfortable with? And I know that Mr. Gibbs has others that are going to testify, but there are some major concerns that I have, especially with the sewage backup and the forest conservation. Those things are concerning to me as well as I'm hearing is concerning for them. So I accept your testimony and what you're saying as far as transportation. But I would hope as we continue to move through this process that there are broader conversations that you all have with the community to really figure out how do we ease some of those pain points that they have, because congestion and that traffic on 210 is a huge concern. And I know as a legislator, we put in countless bills to put in speed light cameras just to slow people down. Right? So when you're talking about adding in more residents and more cars on the road and the ability for those that can be impacted by that, I think in all fairness to them, we need to have a broader conversation. So thank you for your testimony.
Chairperson, as Alex Votaw for the record, I believe I have the right to cross-examine this witness. Is that not correct?
You do.
Thank you. May I take that opportunity now, or was there something else that I should wait for?
No, the floor is yours.
Thank you. Good evening, Mr. Lenhart. Nice to see you virtually, or afternoon, sorry. I had a few quick questions. So when you say that they have the right to produce a certain amount of traffic already, that's under the prior CSP approval. Is that correct?
It's under the existing or the previous preliminary plan approval established a trip cap, and this property, along with all properties throughout the county, received an automatic certificate of adequacy on April 1st of 22 that carried those approvals forward.
Okay, so is it your testimony then that this applicant, even at preliminary plan stage, will not actually have to get a certificate of adequacy?
No, they will need to get a certificate of adequacy at preliminary plan. They have an existing certificate of adequacy that would need to be amended at the time of preliminary plan. And there's language in the code that carries forward a credit for the capacity that was reserved under the original approval.
Got it. So let
and-
me, I just want to make sure I'm understanding.
Yeah.
So they have a previous preliminary plan that allows them to create a certain amount of traffic. But this is a different plan, is it not?
Yes.
And so under the zoning ordinance for this new plan, the applicant has to show that the existing or funding facilities would be adequate to carry the anticipated traffic for this existing plan. Is that correct?
When you say this existing plan, do you mean the previously approved? You mean the one?
No,
that's
I
before the board?
apologize. I mean, this plan CSP 23002 that's before the board.
Yes, and yes, it requires a traffic study and a test for adequacy.
So the adequacy that was previously provided isn't actually relevant to the review of this new plan that's not amending those previous plans, correct?
I believe that it is relevant. There's an existing certificate of adequacy that is currently and still valid that will require an amendment, and the subdivision regulations states that projects shall be credited with the capacity reserved at the time of the original approval. There were a number of aspects of adequate public facilities that were not tested
I'm
with the
sorry to
original
interrupt,
approval.
but I just want to keep it focused on the requirements for approval of the CSP before the board.
Mr. Chairman, I would ask that Ms. Votaw stop interrupting the witness when he's answering her question, please, and let him fully answer before she tries to go into another question.
Well, in all fairness, you're interrupting now, so
Mr. Chairman, I had to. Thank you.
I understand. But go ahead, Ms. Votaw, you have.
Thank you. So again, I just want to confirm finally that the regulations for this board, when they're considering this CSP application before them, requires this board to make a finding that the existing facilities or the fully funded proposed facilities will be adequate to carry the anticipated traffic from this CSP application. Is that correct?
Yes, that's correct. And I believe that
thank
our
you.
study shows that.
And I believe that's all I have. Thank you, Mr. Lenhart, and thank you, Chairman, for indulging me.
Mr. Chairman, I'd like to have Mr. Mark Ferguson come up next, and he's primarily going to address woodland conservation issues. Thank you.
Thank you.
Somebody left their cell phone at the, yeah. Thank you, Mr. Chairman. Good morning, and I'd like to also extend a welcome to you in your new role as chairman. I will also attempt to be brief and limit my testimony to 5 minutes. My name is Mark Ferguson. I'm a 36-year Prince George's County resident with offices in Upper Marlboro as well, here on behalf of the applicant. I think the first bit of context that's important to bring out is that this project, this type of development at this location has been in county planning for more than 30 years at this kind of density. So when we look at the development proposal, it's not coming out of the blue. This is a continuation of a long history, which Mr. Gibbs described to you at the beginning of the applicant's case. The forest conservation is actually a part of that planning. When you look at the forest conservation plan that has been in place since 1999, which is proposed to be amended today to accommodate this conceptual site plan, it has never proposed any forest retention on the subject property to ultimately be the case. It has always been proposed since the very beginning to be cleared for development. A prior type 2 tree conservation plan did in fact leave this area as preservation area so that the responsibility for acquiring off-site credits, which constitute only a part of the total woodland preservation associated with the entire Signature Club project, of which this is just pod 3, could be kicked down the road to a later date. That later date is now. So the forest retention area, which was in fact placed on the property by a TCP2, was there, but only as a placeholder. The planning intention had always been to remove the trees on this subject property. Ms. Votaw, in her objection, raises a number of complaints about procedure. I think Mr. Schneider's staff report that is in your backup was exceptionally thorough, gave you a long history of the tree conservation on the project, how it does qualify for review under the prior woodland conservation regulations that were adopted last year, prior to the ones that were adopted last year, that the conservation requirement was evaluated in accordance with the procedures and priorities in the code, which don't require preservation absolutely to be provided first and only that, but describes it as a recommended priority. And so in the context of the approved development, which, as I said, has been part of the county's planning for more than 30 years, the appropriate choices were made in the review of this project by the applicant and by your staff. I think that's a fair assumption. I know Mr. Burke is here and he can give you more technical details if you wish for that on forest conservation, but I thought I'd give you the high level.
And I appreciate that. You know, I think at the end of all of that, my concern still goes back, and I understand policy, but I also understand the importance of conversation. And I'm not sure if that policy or regulation was echoed to the community, so they fully understand what was before them. And it goes back to what I said earlier. I would love that as we continue to move forward, that there are broader conversations so folks understand what's happening before they come here. Because I think if the conversation was had before they got here, this hearing would run a little bit smoother than what it is now. And I would not be saying what I'm saying now because you all have already had the conversation with the community. So,
and I certainly appreciate and applaud your remarks. Certainly, Mr. Gibbs did tell you there was a lot of outreach. The nature of the system is that outreach doesn't reach everybody, and sometimes it's folks who just hear about a project for the first time when they see the signs appear.
There's always two sides to every story. I get that. But to my broader point, and I'm going to conclude on that, is that I just want to make sure that we're doing all we can to outreach is kind of broad, right? But the information is still the most important thing that they understand. And from what I'm hearing from them, those points were not conveyed.
Understood.
Thank you.
Thank you, Mr. Chairman.
May I cross-examine? This is Alex Votaw for the record.
I'm sorry. Yes, ma'am.
Thank you, Mr. Chairman. So I just have a few questions. I recall you testifying that their previous tree conservation plans for the overall development that contemplated clearing the subject property. Is that correct?
That is correct.
Were those plans including both out parcel B and parcel 12 and lot 12?
They did not. They included only parcel 12. The current plan is an amendment to extend its coverage to outlot B.
So when you're testifying that the previous plans always contemplated removal of trees on this property, that does not include part of this subject property out parcel B, correct?
I would say that the prior TCP1 did not contemplate land outside of parcel 12 that is proposed
under an amendment that's before the board today.
So can you explain to me what the previous TCPs for out parcel B contemplated for that site?
I do not believe that there has been a TCP. Okay, let me say this. I'm not familiar. I did not review the TCP that may have been associated with at least a part of parcel B. I don't know whether in pursuing the townhouse development on the portion of the property on the west side of Manning Road that extended to the subject property or not. I'm simply not aware.
So you don't know whether, for example, the development of the other part of parcel B satisfied the forest conservation requirements through on-site preservation of out parcel B. Is that correct?
I have not reviewed that plan. That plan, however, was prepared by a different property owner.
Got it. So you don't know whether or not, for example, if this tree area was removed, essentially the tree conservation required for that other development would no longer be satisfied. Is that correct? You don't know one way or the other?
When you say this tree area, do you mean the portion of the woodlands that is on Outlot B only?
Yes, sir. Yes, sir.
That is correct.
You wouldn't know.
I do not know definitively.
Okay. And then, so from what I'm understanding from your testimony, the preservation of the trees on lot 12 was used to satisfy prior forest conservation requirements on the last TCP2. Is that correct?
That is correct.
And now that tree area that justified the previous development is being removed. Is that correct?
That is correct.
And does this applicant have to compensate for the change in the satisfaction of the tree conservation requirements for the previous approval now that he's removing those trees?
Yes, effectively he does, because in this case, by acquiring offsite mitigation, as was always contemplated in the type 1 TCP for the overall site.
But it's true, is it not, that offsite preservation has never been purchased? Is that correct?
Offsite preservation is purchased all the time for all sorts of projects.
I'm talking about this project. It's true that in the staff report, they explained that there was a requirement to purchase 7.19 acres of offsite preservation, and that did not occur. Is that correct?
I cannot speak to the 7.19 acres and what should have been done. What I can say is that the type 1 tree conservation for the overall project contemplated the acquisition of almost 30 acres of offsite credits as a part of the whole project, of which this would represent a part.
And you don't know whether or not that acquisition has ever occurred, do you?
I'm sorry, which is that acquisition?
The purchase of the 30 acres of offsite credits.
Well, I can say it is not, because that doesn't happen until just before grading permits, which would be after a subsequent TCP2 to complete the entirety of the area covered by that type 1 TCP.
Okay, well, let me rephrase then, just so I make sure the record's clear so the board is fully aware of what they're approving. Do you know whether or not the offsite preservation credits have been purchased that were required for all of the development that has already occurred that was proposed by that initial TCP1?
I can tell you it absolutely, all of the credits have not yet been purchased, nor should they have been.
For the existing development that already got grading permits?
I'm sorry, you're saying both the existing development and all of the development covered by the previous TCP1.
No,
It's either one or the
I'll
other.
rephrase just to make sure it's clear. I apologize for the miscommunication there. Do you know whether or not the offsite credits required for the existing development that has already been developed, have those all been purchased?
I have not, I do not know.
And do you know whether or not the amount that had to be purchased was adjusted based on the preservation of the forest on lot 12 for the previous development?
I'm not sure I understand your question. Certainly, whenever you come back and take areas out of temporary preservation and propose development that requires offsite mitigation, you would need to purchase those credits. And the purchase of those credits might change
ratios, it might change the total amount that's purchased. It's a bit of complicated math. So
Could you explain for the board what that math is?
Ma'am, let me finish if I could. So certainly, and I'll reiterate what I said before, until everything is done, all of the area covered by the entire type 1 tree conservation, the final accounting will not be complete. So whether it's incomplete now, certainly it is, regardless of what the proposal would be.
Okay, so I now have a question. So is it your testimony that this applicant and no applicant within the Signature Club is required to purchase offsite credits until every single part of that original development is fully developed?
No, absolutely. I never said that. That has to be determined at each phase of TCP2 implementing it.
Okay, that's what I thought. So then my question is, can you explain for this board how this applicant, or let me rephrase just to make sure I'm clear. Can you explain for the board the math that justifies the removal of these trees and whether or not the site is meeting the requirement of, I'm going to rephrase, sorry. I'm trying to be clear, but there's so many different pieces, like you said, and I just want to make sure we all understand. So the forest on lot 12 was preserved to accommodate a previous development. Is that correct?
I would say, to be most precise, the forest on lot 12 was preserved to defer the requirement for purchase of the offsite credits until the end of the total development of the Signature Club, which is essentially now. That's probably the best way of stating it clearly.
Okay, so then when the staff report and your TCP is calculating the amount of offsite credits, are you accounting for the amount that was deferred by the previous development?
Yes.
And how much is that?
I would have to have the TCP in front of me to be able to give you the number, or Mr. Burke may be able to speak to that. But certainly that's what the worksheet on each TCP contains.
Do you know how much woodland conservation offsite credits are being purchased in this case?
Well, in which case? For this?
In this case before the board, in this TCP?
For just this application or for the entirety of the Signature Club development?
For the part of the application that's removing these trees?
Off the top of my head, I do not. If I look at the type 1 TCP, I could be able to tell you.
And okay, let me just ask this. Do you know the ratio of credits? Is it usually 1 acre removed to 1 acre purchased?
It varies with the amount of clearing. So under the old regulations, there was a requirement of if you kept your clearing above the woodland conservation threshold, the requirement was 1 acre of replacement for every 4 acres of clearing. If your clearing was extensive enough to go below that threshold, then that replacement requirement was multiplied 8 times to 2 acres of replacement for every acre of clearing.
So I guess my question then is, if lot 12 preserved, let's say 12 acres of forest to accommodate that previous development, if they were to meet that offsite, would that require essentially 12 acres of woodland conservation credits?
I could not answer that without looking at the detailed math on the worksheet.
Okay, and neither you nor the other, do either you or the other witness have those numbers ready to explain to the board?
Mr. Lenhart certainly does not. I did not bring copy of the type 1 TCP. Mr. Burke is available from the environmental planning staff. And if the board decides, perhaps it would be better to hear that from me.
Ms. Votak, is there a specific question that you have? Because we're going around and around right now.
What I'm trying to figure out, Mr. Chairman, is from my understanding of the staff report, they're only required to purchase 1 acre, roughly 1 acre of offsite woodland credits to accommodate this site, as if this was a new development and not contemplating the requirements for woodland conservation that were associated with the previous stages of development. In other words, the applicant keeps saying this property the forest on this property was held to push the offsite credit purchase to a later date. And I just want to make sure the board is getting verification that this application, which is the later date, includes the purchase of all of those credits, because these pieces of property are owned by different entities. So I'm truthfully very skeptical that the offsite credits that are the right amount are actually being purchased by the correct people.
Yeah, and not to be presumptuous, I think the board understands the direction that you're going. And we're very clear on his testimony and what is already been given.
Then I'm done. Thank you.
Thank you, Mr. Chair. That's all we have on rebuttal, Mr. Chairman, and we're ready to sum up at the appropriate time. I believe the applicant has a final opportunity to speak.
Yes. Any questions from the board?
Yeah, and it's clarifying, and I think it's to you, Mr. Gibbs and or Mr. Hung. One of the citizens testified about the sidewalks, and I noticed in your exhibit, Mr. Gibbs, you talked, I think it's condition 2A, where you were suggesting removal of 2 sections of internal, and Mr. Wong, you didn't specifically comment on that particular condition. So I'd like to know where we're landing. Is 2A staying the same, or are you in agreement with Mr. Gibbs' recommendation to?
Yeah, yes, that is it. For the record, this is Emery Wang with a design. This is Emery Wang with Urban Design. Staff is in agreement with the attorney's statement.
Okay, very good. Thank you, because I know that was also one of the citizens' concerns. That's it, Mr. Chairman.
Geraldo.
I do. Mr. Gibbs, can you tell me, and I've heard about the sewage problems across the road, the ones is that the same developer, same builder?
It's a different developer.
Okay.
And I'm going to hit all that in my comment.
Okay.
I'm going to.
And I understand with Mr. Lenhart with the mitigation, but I was wondering whether or not you guys can make it a condition of this to do the mitigation for the, I live there. I live in Fort Washington. I'm very sympathetic with the residents' concerns about 210. It is by far the most dangerous. I agree with the chair, road in the country. And there were 2 accidents, as the gentleman spoke, last week or the week before, in which there were 2 deaths. So I think it's a legitimate concern of the neighborhood in terms of how to deal with that.
Yes, and I'm happy to do it now or do it when I sum, but
okay.
That's fine. We're fine to accept that as a condition right here.
Okay, great.
Yes, someone.
So applicant gets the final say. This is it. Is that correct?
That's correct.
I believe I have the right to summations as well.
She does. I'm sorry.
Should I go first or does Mr. Gibbs? I believe I go first before Mr. Gibbs.
Yeah, you go first.
Okay, thank you. And I'll keep it brief. I really appreciate the board's time. I just want to make sure we understand the record, that communities' voices are adequately heard. So to summarize, again, this is Alex Votov for the record. I think this case clearly demonstrates the issues with this approach, which is I want to rely as a developer on my previous approvals, but I want to finagle the rules around so that I can do what I want. This application combines 2 properties that were not part of a previous CSP. I do not believe the transitional provisions allow that. And the applicant continuously says, I'm relying on the previous TCP to meet these requirements. Don't worry about the forest conservation plan. It'll be addressed when the whole development is concluded. I'm relying on the traffic capacity of the previous development. Don't worry about the amount of traffic I'm adding because it was already contemplated. But the fact of the matter is this applicant is providing a new CSP. If the applicant is providing a new CSP, which is combining 2 properties that were not previously contemplated together, the applicant needs to demonstrate that the traffic provided or anticipated with this new development will be adequately handled by the current traffic conditions. It does not matter what was previously approved. It does not matter previous adequacy determinations because the applicant has a new application. They must meet the requirements of the law. And this board has the authority and I believe the obligation to deny this application because the record is crystal clear. The facilities that are existing or are currently funded do not have the capacity to handle the traffic anticipated with this new CSP application. You have that power, and I believe you have the obligation to protect this community from that impact. At the very least, you certainly have the power to require the applicant to take mitigation matters to fix this problem in association with this application. I also want to touch on the tree conservation plan. I am very concerned about this tree conservation plan. The applicant did not provide evidence to demonstrate how it is going to meet the requirements of the Forest Conservation Act. And as witnesses very clearly described, removing forest in this county in particular, which is already hemorrhaging woodland left and right, is hugely detrimental to this county, to the community, to its residents. It causes health issues, it causes flooding issues, it causes septic issues, it causes asthma issues, it causes other public health issues. These are all far more expensive to deal with after the fact than they are to deal with by making sure the applicant is actually satisfying the requirements of the law before you approve the application. And again, this application has never justified why it cannot provide any woodland conservation on site, not 1 acre of woodland conservation on site. The applicant again has justified that by saying, oh, the previous TCPs contemplated removing all of the woodland on this site. That is not true. The previous TCPs contemplated removing woodland. I'm going to rephrase that. That's not true because the original TCPs contemplated removing trees only on parcel 12. There's no evidence that any prior TCP contemplated removing all of the woodland on out parcel B, ever. Furthermore, an amendment to the previous tree conservation plans, the last TCP2, designated this site for forest retention. And the applicant's witnesses have not been able to articulate to this board how this overall development is going to comply with the forest conservation offsite mitigation requirements. Because what I'm going to be frank with you, board members, what this applicant is going to say, and I understand why they say it, is they are responsible for getting the offsite mitigation only required for this parcel. So then who, I would like this board to consider, who is paying for the offsite forest conservation mitigation for all of the previous developments which continuously pushed off satisfying that requirement until a later date? Who is going to be responsible for that? Because it's not going to be this applicant, based on the staff report, which stated that 7 acres of offsite mitigation credit has never been purchased and does not require this applicant to do so. And it's certainly not going to be the previous developers who no longer own the property and some of which are being sued. So again, I strongly encourage this board to seriously consider the concerns of the community, the legal issues with this application, and deny both the CSP and the tree conservation plan. I greatly appreciate your time and consideration in this matter. Thank you.
Thank you, Mr. Gibbs.
Thank you very much, Mr. Chairman. And let me first address the last comment about the tree conservation issue. Okay, we have filed a TCP1 with this conceptual site plan. It has been reviewed by staff. Staff has come to the conclusion that the preservation requirement for this particular application is 1.78 acres offsite purchase of easements. That's what we can control. We cannot control anything else. And I would, again, I've invited Mr. Burke, who is in control of all of this information, to provide information to the board, but he has not done that thus far. I can just tell you that this applicant, which is separate and distinct from any other applicant who has done anything at Signature Club, okay, is meeting its tree conservation requirements. The TCP1 did not ever presume that this lot 12 was going to be left totally wooded. That was never a presumption. There was a push forward to the future issue, but my client, Wood Partners, their obligation is to deal with the development of this site, and they have presented a tree conservation 1 plan. It has been reviewed and approved, and we're willing to abide by what the requirements are that are imposed upon us by the Park and Planning Commission review staff and ultimately by the planning board, the TCP 1 that's being approved. First, let me talk about citizen outreach. I have done a fair amount of work in the Accokeek area over the course of time. We have an organization called the Accokeek Development Review District Commission. That has always been my point of contact for starting citizen outreach, which I have never ignored in any case that I have ever handled in this county. I contacted the chair. I reached out to the chairman, the person who was the chairman for years, who I dealt with, Mr. Clifford Woods, by email, by telephone message, by text message. I got no reply. I talked to a representative of the District 9 Councilmanic office. Is there somebody different for the Accokeek Development Review District Commission? I don't know.
Called Cheryl Summerlin, who provides all of the contact information for mailing out informational mailing letters and
acceptance letters. We have a contact for the Accokeek Development Review District Commission. Yes, his name is Clifford Woods. That's the person I was contacting. We dug deeper and deeper. Ultimately, we found out that Mr. Woods unfortunately passed in February, and no new chairman has been named. I said, could you get me a contact person for the Accokeek Development Review District Commission? Community Planning gave me a contact. I reached out to those individuals. The earliest time that they could meet with us is a week and a half into the future. We are going to meet with them. I have always met with the Accokeek Development Review District Commission. I have always attended their meetings in person and conducted outreach to everyone who attended those meetings. In addition, the area that is Pod 2, which is the 313 single-family and townhouses in Signature Club, some of whom spoke today, they have their own homeowners association. I reached out to that homeowners association and requested a meeting. We did have a meeting with their board of directors last week. We heard all of their concerns. We provided all of the information about this project. I sent informational mailing letters to everyone on the list who was provided to me by the Park and Planning Commission. I also sent acceptance letters to everyone on the list that was provided by the Park and Planning Commission. I filed affidavits of the mailing of both of those letters. My law firm and I personally, we value and faithfully observe the requirement and the importance of reaching out to the general public. I did receive a call from Mr. Christensen. He and I have engaged in a couple of different phone calls. I have sent him information. I sent him a copy of the actual proposed site plan for this project, which hasn't even been filed yet, that showed buffering along his property. We've intentionally not proposed to put a sidewalk along our portion of our property that abuts his property because he has a concern about people walking into his 10 acres from the development of this site. So with the utmost of respect, I don't want to come down here and have 15 people show up who are complaining. Now, sometimes when you have all the outreach in the world and all the meetings, that still happens because people just are not satisfied. And they have the right to do that. And I totally respect that right. If people don't want a multifamily project, then, they're going to come down and tell you that. And again, I respect that. But please understand that we have done our utmost to conduct community outreach. I just don't know what more. My starting point has always been the Accokeek Development Review District Commission. And when I have gone to meetings there have been lots of folks who have appeared, and we have had very successful dialogues. So I'm just trying to convey to the board, we're not trying to avoid meeting with the public in any way whatsoever. I want to turn my attention, if I could, some comments that were made by folks during their testimony. There was a concern raised by one of the speakers, Karen Thomas it was, about being able to cross Berry Road to get to the shopping center, because there was a concern about whether the retail that was part of this overall project was walkable. There is a crosswalk which has been installed at the traffic light on Berry Road near its intersection with Manning Road. And that light, I believe, is phased to allow pedestrians to cross over to get into the shopping center. There has been a lot of conversation about Pod 2. That is the area where folks are talking about sewage backups. When my client purchased Pod 2 and Pod 3, there was already a private sewage treatment plant installed on what was part of parcel 25, if you recall that drawing that I looked at. My client who purchased the property inherited that. That was installed and approved prior to there being any residential development. My client sold Pod 2 to a totally different developer that has nothing to do with Wood Partners. That developer developed those 313 lots. There were two builders that came in and split the construction. The two builders were NVR and Caruso Homes. Mm-hmm. Those homes were constructed. There were some backups that occurred because of the level at which the individual pipes and units were installed and how it connected to the private treatment plant. And I don't know anything about lawsuits down there. I haven't been involved. I attended one meeting down there with citizens some time ago at the treatment plant, along with the District 9 council member. But I can tell you right now that Wood Partners has nothing to do with that project. Approving this project is not approving another development opportunity for the same developers who built the 313 units. And so I just would like to get that information clearly on the record in front of the planning. In terms of traffic and transportation. So there was an overall traffic study done for the entirety of the project. Then there was a traffic study done at the time of the approval of preliminary subdivision plan 4-01-064, okay? Whenever we do a traffic study, the traffic engineer has to have a scoping meeting with staff at the Park and Planning Commission. That traffic study was scoped. There were intersections which were identified to be tested. I think there were 3 intersections tested as part of that preliminary subdivision plan. All of those intersections passed. That preliminary subdivision plan was approved, and that yielded the 157,500 square feet of commercial development. When this conceptual site plan was filed, okay, the trip cap that was approved for Lot 12 and Outlot B had been vested, okay? Those trips were vested by virtue of making the transportation improvements that were conditions of approval to that original preliminary subdivision plan. And the new subdivision regulations, I think it's 244305, say if you make the transportation improvements that are conditions of your approval, then your trip cap vests. And that's what Mr. Lenhart was referring to. The trip cap that was approved has vested. And therefore, and in that preliminary subdivision plan, okay, in the resolution approving that preliminary subdivision plan, it says, here's the trip cap. And it is for 157,500 square feet or any other use approved in a conceptual site plan. Mr. Lenhart's testimony was that this applicant is entitled to rely upon those trips. Now, He did a new traffic study for this conceptual site plan. He had a new scoping meeting. There were 3 intersections before. This time, there were 8 intersections that he had to test. He took all new counts in April of 2025. He prepared a report. Of the 8 intersections that he had to test, one leg of one intersection, the 210-373 intersection, is failing and was failing before in the PM peak hour. But the interesting concept is that this development causes the PM trip cap to go down below what it was before. So that's why Mr. Lenhart said, we meet adequacy because of that. We were allowed to rely on that trip cap. Now, recognizing that there was more to look at, I asked Mr. Lenhart to say, because look, the transportation adequacy finding in 27546D, which everyone is talking about here, yes, it does say that that you must find that there, quote, and this is important, quote, there will be adequate transportation facilities, will be. When staff analyzed that, they said mitigation is available and the real adequacy of transportation facilities is decided at preliminary subdivision plan, not a conceptual site plan. There is a test that's in 27548D, but it's not the subdivision adequacy of transportation facilities test. It's just that test requires you to find that there will be adequate facilities. And so staff says for the one leg of one intersection out of 8, all the others passed. Out of 8, mitigation will be available at the time of preliminary subdivision plan when the real adequacy of transportation facilities test is applied. Now, recognizing that there would be a concern today, I asked Mr. Lenhart, is there a mitigation technique that you could find to address this 1 PM issue? Because in mitigation, you have to address 150% of your impact on that intersection, okay? He identified a mitigation treatment, and he testified about it today, to split phase the light at 210 and 373 and create restriping on the Livingston Road approach. And his testimony was that mitigation improvement will result in absorption of 300% of the trips, of the impact on the intersection in the PM peak hour. All right, so the requirement would be 150, that's 300. Now, that will have to be approved by the State Highway Administration, obviously, because you're split phasing the light at a major state road. But we're willing to accept that subject to the State Highway Administration approval. But bear in mind, the real nitty gritty of this test occurs at preliminary subdivision plan stage, not here. This is a concept drawing. We have provided so much detail beyond which the ordinance requires in an attempt to be transparent in this case. Normal conceptual site plans don't show, building footprints and circulation like we have here. And, but we did it to try to be transparent. So what we're saying is that to the extent there's an adequacy requirement for a finding at the time of conceptual site plan, we have more than accommodated it. Staff agrees we have accommodated it. And then we went beyond by saying, we don't think mitigation is required, but if you're going to determine that mitigation is required, here's the mitigation improvement. It mitigates 300%, twice as much as what's required under the code provision. So again, that's going to be subject to State Highway Administration approval, but we're willing to accept that as a condition, even here, subject to State Highway Administration approval. And of course, obviously, looking at all of the adequacy of transportation facilities in a very, very detailed fashion when we come in to do the new preliminary subdivision plan for this conceptual site plan. Because notwithstanding anything else, your rule is that if you're taking a commercial, something that was approved for commercial development and you're going to put residential in it, you got to get a new preliminary plan. Similarly, if you're going from residential to commercial, you got to get a new preliminary plan. And so and it's required by the, if you recall, the hierarchy of approvals that I talked about in the beginning within the MXC zone. CSP, conceptual site plan, preliminary subdivision, plan, detailed site plan, final plat subdivision. We have to go through all those. So that information will be provided at preliminary plan. But if you add the mitigation, we don't believe mitigation is required to be done at this point in time. But if the board wants to add it, we're happy with adding that as a condition because it takes away the objection that has been raised. So with that having been said, I just want to reiterate again, Wood Partners had nothing to do with any water problems, nothing to do with any sewer problems. This project is going to be connected to the gravity-fed sewer of the Washington Suburban Sanitary Commission. It is not going to use a private sewer treatment system, as is the case for the Pod 2 development, which is something that the ownership at that time inherited. They didn't do it themselves. They just inherited it. The new owners did. I would simply reiterate that the staff report in this case is comprehensive. We are going to meet the requirements of the type 1 tree conservation plan. When we go on to the next phases, that we get the detailed site plan, we're going to do a type 2 tree conservation plan, a new one for this property. We're going to meet the off-site tree easement requirements. But again, I and my client both respect the concerns raised by the community. And I understand, people don't want trees cut down. But once again, as Mr. Ferguson testified, it was never envisioned that all of Lot 12 was just going to remain trees forever. And so the applicant, I would respectfully say this, not arrogantly at all, but the applicant does have property rights to follow the law and develop their property. And that's exactly and all that my client wants to do. And we support the staff recommendations in this case. And we believe that we have more than carried our burden to obtain approval of this conceptual site plan. I'm happy to answer any questions. Thank you.
Are there any questions for the applicant's attorney? I do. And it's really not questions, it's more statements. And one of the things I've learned over my many years is change is inevitable. It's going to happen. And sometimes we are not comfortable with change, but it's how we deal with it that makes us who we are. And one of the things that I was listening intensely when you spoke about your community outreach in the Accokeek area, and that you tried to reach a man for a period of time, and then to come to find out that he had passed away. And when you start talking about outreach and looking into a community that is not looking for the changes that you're looking for, I think outreach can be done in multifacets. Coming from the background of being an elected official here in the state of Maryland, when we did outreach for campaigning, we had to touch a multitude of people, churches, barbershops, you name it, to get our point across. And even though you were going to one particular entity, I think outreach is multifaceted. So I would ask in the future, when you have those hangups or hiccups, that you really cast the net wide to get your message across from a community outreach standpoint. Because as we move forward within this planning board, it is imperative that those that come before us have done just that. Because it is imperative that the community buys in. And one of the things that I try to preach on my day-to-day is that we must figure out how do we create a win. And the win has to be on both sides, on your side as the developer and on the side of the community. And I believe that there is always going to be room for conversation, but we must figure out how do we create the win. And part of that is making sure that the community has all the tools necessary to ascertain what is coming before them. Second thing is, when you talked about the sewage backup, and you said that you all inherited this. So when I think of inheritance, I think of ownership. That is now mine. So even though you inherited something that was not caused by you, you now own it. And to me, being a good partner is trying to figure out solutions in which I try to accommodate the community as best as I can. And ensuring that from a sewage backup and those that are complaining, what can I do to be a good partner? And even though it may cost me $1 now, you may get it back in the long run, but I'm satisfying a need where people are not complaining. And I think that's the responsibility that we have as a board and that you all have as developers, and that we're trying to transform Prince George's County into what we want it to be. And part of that transformation, in my opinion, is being good teammates, being good partners, communicating with folks, letting them know that yes, change and cut is coming, but I'm going to do all that I can to make sure that I am a good partner in that change. So listen, I think today is my first day, but I'm excited because I think as the days continue to go long, change is inevitable. And I'm trying to create a methodology on how we do things going forward. I'm not my predecessor or the ones that were there before him, that we're going to do things in a more methodical way as we look at change for the betterment of this county and more importantly, the betterment of our residents. So I just wanted to conclude with that. And board members, I understand that there's no more deliberations. So what is your pleasure?
Mr. Chairman, I move that we adopt the findings of staff to include the modified finding as outlined in staff exhibit number 1 and approve CSP-23002, TCP 1-052-97-03, and variance to section 25-122 B1G, subject to the conditions as outlined in staff's report, and is further modified by applicant exhibit number 1 with the addition of the proffered condition as it relates to mitigation. And I would ask that staff and council get together to ensure that the language is codified appropriately.
So there's been a motion by Commissioner Washington and second by Vice Chair Bailey. I will now call the roll. Chair Bailey.
But aye.
Commissioner Washington.
But aye.
Commissioner Giraldo.
I vote on, Mr. Chair. I'd like to thank the community for coming out and for them, encourage them to continue to be diligent in your community. And I vote aye.
And as the chairman, I vote aye as well, with explaining my vote. Because Mr. Gibbs, I hope that you have heard me very clearly on what the expectations will be going forward. Because I think it's important that we take under consideration not only the betterment of your clients, but we really look closely at the community at large. So with that, the yeas have it, and this has been approved. We'll now move on to the next agenda item. Item 6.
Thank you very much for your time.
Detailed site plans, DPS 19021-2, South Lake Commercial. David?
Thank you, Mr. Chairman, and good afternoon, Mr. Chairman and members of the Planning Board. For the record, I am David Meyerholtz with the Urban Design Section. Item number 6, detailed site and DSP-19021-02, which requests approval of additional signage, revised architecture, including a reduction in gross floor area, and additional site details. Next slide, please. The site is located in Planning Area 74A in Council District 4. Next slide, please. More specifically, the site is located on the northwest quadrant of the intersection of US 301 and Marketplace Boulevard within the South Lake development. Next slide, please. The subject property and the rest of the South Lake development is zoned LPD or Legacy Comprehensive Design Zone, but was formerly in the EIA, Employment and Institutional Area Zone. Next slide, please. The site is located entirely within the city of Bowie. Next slide, please. This slide shows the site's topography. Next slide, please. This map shows the adjacent master planned rights of way, which include US 301, classified here as both an arterial and a freeway, Marketplace Boulevard, a major collector, and Fairmount Drive, a collector. Next slide, please. This enlarged aerial shows the site and its recent development, including a giant grocery store, a Sheetz gas station, a McDonald's, and 3 multi-tenant buildings. Next slide, please. This slide highlights where the requested revisions are to occur. The new and revised signs are located along US 301 Crane Highway. The additional site details include plaza furnishings, which are located along Marketplace Boulevard near the bottom of this plan, and trash enclosure screening, which is near the roundabout on this plan. The revised architecture is for pad site 21 near the center of this commercial development. Next slide, please. This slide shows a closer view of pad site 21. Next slide, please. And this slide shows the revised architecture and proposed building mounted signage for pad site 21. Note that this represents a reduction of 22,379 square feet as the building was previously envisioned as a 2-story structure. Next slide, please. This slide shows a closer view of the pad site with new and revised signage. At the bottom left is the revised shopping center gateway sign, and the new monument signs for Chase Bank, McDonald's, and Panda Express are located on the right side. Next slide, please. This slide shows the proposed new monument signs and 1 new building mounted sign for. Next slide, please. This slide shows the revised gateway sign. The revision is only for the change in material of the brown color shown on the diagram from a high-density wood material to a powder-coated metal. Next slide, please. This slide shows the details for the new bench planters that are proposed on the site. Next slide, please. And this slide shows the details for the new trash enclosure proposed for the site. Next slide, please. Finally, this slide shows the landscape plan with the proposed site revisions outlined in red. Next slide, please. Based on this evaluation and analysis, urban design staff recommend that the planning board adopt the findings of this report and approve detailed site plan DSP-19021-02, subject to the recommended condition of approval within the technical staff report. This concludes staff presentation, and thank you very much.
Thank you. Any questions from the planning board? Seeing none, we will now hear from the applicant's attorney, Matt Tedesco.
Excuse me, Chair, Principal Counsel David Warner. Since this is an evidentiary hearing, we do need to swear in everyone who's going to get this.
Notwithstanding the determination by Mrs. Votaw.
Heard it.
Happy to do so.
Raise your hand. I swear that you tell the truth and nothing but the truth.
I do. Thank you, Mr. Warner. Good afternoon, Mr. Chairman, members of the planning board. For the record, Matthew Tedesco with the law firm of McNamee Hosey here in Greenbelt. On behalf of the owner and applicant, Southlake Commercial LLC. First and foremost, I would be remiss if I didn't congratulate Mr. Chairman on your appointmentship to the chair. We look forward to working with you and your leadership and certainly moving the county forward with the efforts of your team. With me this afternoon, we have Mr. Kevin Kennedy and Julian Curry from the N.A. Michaels Company and representatives of Southlake Commercial LLC, and Mr. Nat Ballard with Rogers Consulting. Also from my team, we have Dominic Lockhart, who is our senior land planner, and I would like to introduce the board to a new associate that the firm has, Carly Landolfi, who has joined our firm and will be hopefully assisting, and you might be seeing more of before you and staff may see as well. So I asked her to be here this afternoon just to kind of get a lay of the land and to be introduced to the board. So I just wanted to acknowledge her presence as well. I won't belabor the point. I think it's a fairly, hopefully, straightforward application and case. I want to thank Mr. Meyerholtz for his review. It's always a pleasure working with him and his team, as well as Ms. Connor and her team, and Ms. Hojung Garland as well in the urban design section for this project. Southlake project represents over 25 years of collaboration between the owners, the applicants, developers, the community, park and planning, City of Bowie, and all county agencies. The new housing and retail that's coming out of ground and individuals are purchasing and the options of South Lake in conjunction with the adjacent Liberty Sports Park and the planned indoor sports facility create a purposeful and mixed-use community that is unique in the Mid-Atlantic, if not Prince George's County. My client, who are the owners, have prioritized leasing to small and local businesses, the inline commercial retail spaces, with the majority going to local entrepreneurs and franchisees, and at least half of those businesses are based here in Prince George's County. South Lake is a mixed-use development, approximately 4 million square feet with an FAR of 0.3. As I mentioned before, it's been 25 years in the making. The project fulfills the vision of an integrated commercial, residential, and recreational institutional spaces, centrally located public amenities like a lake, a trailhead, and plazas. It has a number of approvals. We are here on an amendment to the detailed site plan DSP 19021, which was approved for the overall commercial retail center. As Mr. Meyerholtz in his staff report indicated, the revisions are fairly minor in nature, but for the addition of the monument signs, this would have been a staff level limited minor amendment approved by your planning director. But with the addition of the freestanding signs, both modest in scale and in keeping with the character of the center, it was required for us to come before you because the site is developed under the MXT zoning requirements, which mandate that the planning board approve in particular the signage details. And since these are new signs, we had to come before you this afternoon. The staff report does recommend approval. We have no modifications to any of the findings, any of the recommended conditions. We stand before you happy to submit on our justification statement, the record before you, as well as staff's recommendations, and happy to answer any questions that you may have. But at this time, we accept staff's findings and accept staff's recommendations and conditions. And with that, Mr. Chairman, I'm happy to answer any questions, but would respectfully request the board's approval of this application.
Are there any questions from the planning board? And I believe that there are a couple of people that have signed to speak. The first is Dominique Lockhart.
So, Mr. Chairman, let me thank you for that. We do have others individuals who have signed up. They are on behalf of the applicant's team. They do not wish to speak unless there's any questions of the board.
No. And there's no one. Oh, good. This is how you need to come before the planning. All the other land use attorney, now you know what you need to do.
We strive to do that, Mr. Chair.
There you go. Commissioner, is there a motion?
Mr. Chairman, I move that we adopt the findings of staff and approve DSP 19021-02, subject to the condition as outlined in staff's report.
Second. We have a motion by Commissioner Washington and a second by Commissioner Bailey. I will now call the roll. Vice Chair Bailey. Aye. Commissioner Washington.
Vote aye.
Commissioner Geraldo.
I vote aye, Mr. Chair.
You have my vote as well. I vote aye. The ayes have it. This has been recommended for approval. Thank you. We will now move on to the next agenda item, item 7A. Certificate of Adequacy, ADQ 2024-220 Hobson Farm.
Good afternoon, Mr. Chair. For the record, this is Sherry Connor with the Development Review Division. It's my understanding that we have withdrawal that will be verbally submitted on the record by the applicant for items 7A and 8A.
Great.
Mr. Chairman, approach.
Yes.
I was making sure Mr. Warner didn't want to swear me in, but I don't think I'm testifying at this point. On behalf of the applicant DR Horton Incorporated for items 7A and 8A, I agree with as Ms. Connor indicated, we are here to withdraw the appeal that was previously filed for the certificate of adequacy associated with those applications respectively, and I can come back when we get to item 8 if need be. But I do stand before you here to withdraw the appeal of the certificate of adequacy, given the approved certificate of adequacy that was issued in each of those cases as a result of the County Council's adoption of CR 80 2025. So with that, we will be withdrawing that appeal.
Thank you. Is that also 7B?
And then now move to 7B.
We will now move to 7B. Staff.
Okay. Good afternoon, Mr. Chair and members of the board. For the record, my name is Mahsa Kandus with the subdivision section. Item number 7B on the agenda is a preliminary plan of subdivision for Dobson Farms 4-24014. The subdivision proposes 1,020 lots and 140 parcels for development of 678 single-family detached and 346 single-family attached dwelling units. Before I continue, staff would like to note that the published technical staff report recommends disapproval of this preliminary plan based on the denial of accompanying certificate of adequacy for this case. However, since the technical staff report was published, the certificate of adequacy was considered by the planning director as allowed under the council resolution 080/2025 adopted this past Tuesday, and the certificate of adequacy is now approved with the conditions. Therefore, staff is now recommending approval of this preliminary plan, which is supported by the findings and conditions provided in the published technical staff report, and now supported by an approved certificate of adequacy ADQ-2024-020. Furthermore, as a matter of housekeeping, 2 additional items of backup were submitted prior to the noon deadline on June 8, 2025, including applicant's Exhibit 1, which includes requests to revisions to a condition of a technical staff report and testimony of Brandywine TV Southern Region Neighborhood Coalition, which will be discussed further in my presentation. Next slide, please. The site is located in the southern part of Prince George's County within planning area 85A and Council District 9. Next slide, please. More specifically, the site outlined here in red is located south of McKentry Road, approximately 1,400 feet west of its intersection with US 301 Robert Crane Highway. Next slide, please. The zoning map shows that the site outlined on this slide in red is zoned Legacy Comprehensive Design Zone as shown in the image to the right. However, this preliminary plan of subdivision was accepted for review under the prior zoning ordinance and prior subdivision regulations. And under the prior zoning ordinance, the site was in the residential suburban development zone as shown in the image to the left. Next slide, please. The site map shows that the site outlined in circle and indicates the topography on the site. Next, please. The master plan right-of-way map shows that the subject site has frontage along master planned McKentry Road, which is classified as major collector roadway. Next slide, please. This preliminary plan of subdivision proposes to subdivide the property into 1,024 lots and 140 parcels for residential development consisting of 678 single-family detached and 346 single-family attached dwelling units. This overall view of the preliminary of subdivision shows the layout of the proposed lots and parcels with the property boundary outlined in red, public right-of-way in light blue, and private rights-of-way in dark blue. The property is also associated with primary management area shown in the hatched purple line. This preliminary plan of subdivision is associated with an approved certificate of adequacy ADQ-2024-020, which was approved in accordance with the subdivision regulations to ensure that infrastructure necessary to support proposed development in accordance with the established level of service standards for public facilities are adequate. Next slide, please. This slide shows that the TCP1 tree conservation plan with the proposed on-site woodland preservation areas highlighted in green. The site has a woodland conservation requirement of 103.80 acres, and the applicant proposes to meet the requirement with 101.98 acres of woodland preservation and 1.82 acres of reforestation. Woodland conservation and staff analysis are further detailed on page 30 of the technical staff report. The primary management area is shown on this slide in hashed purple line. Impacts to the primary management area were previously approved for infrastructure, and 3 new impacts are requested with this application. Those 3 impacts associated with this preliminary plan are specifically to accommodate the trail system. All impacts are indicated on this slide by letters A to Z, and the requested PMA impacts and staff analysis are further detailed on pages 33 through 35 of the technical staff report. The applicant has requested a variance from section 25-122B1G, which requires preservation of specimen trees. This preliminary plan of subdivision proposes removal of 15 specimen trees on the site, the location of which are shown by red circles on this slide. This variance request is supported by required findings for approval and discussed further in the environmental findings on pages 30 to 33 of the technical staff report. Next slide, please. The subject site proposes 3 access points that will all facilitate right in and right out movements. The preliminary plan proposes the overall 42.86 acres of public roadway dedications. Within the site, a 10-foot wide shared use path for the alignment of Metawoman Creek Trail, bikeway facilities, and sidewalks along both sides of the roadway are proposed. Sidewalks are shown by hatched orange lines, trail by hatched green, and shared paths by hatched purple lines. Next slide, please. This slide shows the location of green open space area highlighted in light orange, the recreation facility areas highlighted in purple, the woodland preservation area in green, and the floodplain area in blue. Next slide, please. As mentioned at the beginning of this presentation, staff received an exhibit submitted by the applicant as additional backup material for the preliminary plan of subdivision. In this exhibit, the applicant requested a revision to condition 18 related to the timing of the proposed trail construction. Staff has reviewed the proposed revision and recommends that the applicant's proposed language in blue at the end of the condition be replaced to state with timing of the trail construction be determined at the time of the specific design plan for the residential development. It's the staff's understanding that the applicant is in agreement with the revised language as recommended by staff. Additionally, staff has received a testimony from Brandywine TB Southern Region Neighborhood Coalition in support of the staff's initial recommendation of disapproval, specifically due to concern regarding failing the police response time. However, the evaluation of police response times is outside of the scope of this preliminary plan or determined under the certificate of adequacy. In conclusion, the subdivision staff recommends that the planning board adopt the findings and approve the preliminary plan of subdivision 4-24014 Type 1 Conservation Plan TCP 1-011-2023-01, as well as the variation request to Section 24 128B7A, and a variance request from section 25-122B1G, subject to the findings and conditions in the staff report with modified condition 18 in accordance with the applicant's Exhibit 1, as further modified by reading to the record by staff. This concludes the staff's presentation. Thank you.
Great job. Any questions from the planning board?
Clarifying only. You said variation from section 24. Is it 20? I just want to make sure it's 25. You said 20?
Variation is 24, the variance is 25.
Got it. So this needs to be up. Okay. Thank you very much.
We will now hear from the applicant's attorney, Matthew Tedesco.
Thank you, Mr. Chairman. For the record.
Chairman, I would interrupt and suggest that at this time we swear everybody in who is intending to provide testimony, including Mr. Tedesco. And we do have some people signed up.
Yep, I agree.
Thank you. So those of you who intend to provide testimony and anyone online, please raise your right hand and swear to us that you affirm to tell the truth and nothing but the truth.
I do.
Thank you.
Mr. Chairman and members of the board, although we have a number of people that stood up in the back of the room, at least most of them, I think, are for the applicant, and again, will only need to speak if directed by me, so I didn't want there to be an overabundance of concern that I intend to call.
I did have that concern.
I don't have any intention of calling any witnesses unless needed in rebuttal based upon anything that we may hear from any of the citizens that choose to testify in this case. For the record, again, Matthew Tedesco, law offices in Greenbelt, here on behalf of the applicant, D.R. Horton Incorporated. As I mentioned, many of those folks that you saw stand up are members of the development team as well as the applicant team. You have their names. I won't belabor the point by delaying this hearing any longer, but we have a number of representatives from D.R. Horton, who is the contract purchaser and applicant in this case, as well as in the case after this one. We have a number of representatives from the design team from Rogers Consulting with us this afternoon. As I mentioned before, members of my team with us, and then members, Mr. Mike Lenhart from the Lenhart Traffic Consulting Group. So we do have a full assemblage of the folks with us that help make these large, complex projects come to fruition, to no exclusion of your staff, your excellent staff in the urban design, in the subdivision section and development review division. And I want to thank Ms. Van Duus for her review of this case, Ms. Gupta as the supervisor, certainly Ms. Connor for her review and work in this application. It's been a lot of back and forth on this particular project as well as the next one. With respect to an issue that I have dealt with for more than 10 years, if not longer, with respect to police response times, in particular in this part of the county. And if you would just indulge me, Mr. Chairman, and I think Mr. Warner and I have spoken about this, notwithstanding our withdrawal of the appeal of the certificate of adequacy, given the fact that it was recommended for, or was approved by the planning director, initially denied, in light of the preceding legislative action that occurred this week. I do want to just make sure from a record perspective, procedural perspective, that the legal memorandum that we submitted both in the appeal case but also as a companion to this case is in this record. I believe it is in the additional backup, but I just wanted to just confirm that with Ms. Connor. And with that being said, Mr. Chairman, for the record, and if you would just indulge me, notwithstanding the execution of the mitigation agreement and the adequate ADQ conditions of approval, the applicant expressly does not waive any legal objections or rights to later appeal or challenge the police response time and mitigation agreement resulting from the ADQ conditions. We explicitly reserve all rights to challenge the validity, legality, and constitutionality of the application of the police response time test and imposition of the conditions and mitigation. Accepting of the ADQ conditions and execution of the mitigation agreement is made solely to avoid the only alternative imposition of unconstitutional conditions that would result in undue delay and obstruction of the underlying project and approval of preliminary plan 4-24014. With that behind us, let's turn to the actual reason why we're here with respect to the preliminary plan subdivision. This project has as you can imagine, a project of this size and this scale has a very long history. Your colleagues on the board are familiar with it as they have approved and reviewed various applications over the last 5 years. But it stems back even our involvement for at least over 5 years. Prior to that, the involvement of the master plan in this area going back to 2013, originally 2009, and then readopted in 2013. It has a long history of surface mining operations being sand and gravel, going back more than 45 years. The property has also been extensively farmed over many years. From the initiation of this project, even before the basic plan was approved, recommended for approval by this body and ultimately approved by the district council back in 2022, the vision and goal was to create the best possible land plan while preserving and enhancing the property's unique and special environmental features. Those environmental features are made up of the Timothy Branch and the Mattawoman Creek, which bisect the property, and their associated tributaries, creating a very unique and special, well-planned and well-designed community. There's no doubt, as supported by the staff and all reviewing agencies, that this preliminary plan of subdivision advances this vision and goal and satisfies all the required findings for approval. This application and the project design results in and produces a sustainable, resilient community in a village-like setting that takes advantage of the nature and environment while also improving upon those factors. From its inception, going back to the basic plan, which I mentioned before, was approved in 2022, but we actually started that process in 2020. We came up with, and they've been advanced not only by this body, but by the district council, 4 environmentally enhancement goals that have been advanced as conditions as part of the basic plan, carried forward as part of the conceptual design plan, and analyzed within your staff report. And those are stream restoration, stream and woodland preservation, environmental site design, and restoration, enhancement, and preservation of the portions of the property formerly in the rural tier, being the far western property, which is not proposed for development, saving, of course, the master plan trail that will meander through those woodlands. These goals are met through proffers made by the applicant with the basic plan and carried forward. Provide stream corridor assessments with the NRI, on-site woodland conservation. And for this application, the entire woodland conservation thresholds are being met on-site. Create new wetlands and enhance existing wetlands and adjoining meadows to focus on providing wildlife and habitat. Provide selective woodland understory enhancements focusing on habitat and biodiversity. And provide ecological enhancements through selective environmental site design plantings. As I mentioned, there have been a number of approvals for this project going back from the basic plan, the CDP, and most recently, a year ago, the specific design plan for infrastructure. With those approvals in hand, we are now advancing the preliminary plan of subdivision. As part of the preliminary plan of subdivision, section 24-119D requires the planning board to make findings related to conformance with prior approvals, adequate public facilities which are been determined pursuant to the approved certificate of adequacy that are not subject to this application, probative findings that, strike that. I want to highlight a couple of points with respect to the master plan and this project. We've heard various things throughout the many years of this project, terms like sprawl and things of that sort. And I always find that confounding when we have a master plan and the goal and the policies, at least of the current district council, has always been to follow the plan. This project and the project after this case did just that. The master plan for this area recommends residential low development. So although you see before you a mix of dwelling units consisting of 678 single-family detached and 346 single-family attached, that's not sprawl in the sense that it still meets the residential low land use category. Residential low in the master plan and the general plan is 3.5 units to the acre. This application proposes 2.16 units to the acre. I will note that as part of the basic plan, there was even higher density. We have systematically reduced that density as each of these plans move forward, which is what happens. As you get further along in the development process, things get further focus, and ultimately sometimes you gain density, but you can never go over the ceiling. Sometimes you lose density. That's what's occurred in this case. We've actually reduced some of the density from what was originally approved with the basic plan. As I mentioned before, 678 single-family detached, 346 single-family attached, providing a mix of housing types, different sizes, different price points, all within areas of the project that are within the residential low land use recommendations. This will support the county's goals of affordability and variety, as well as address the housing shortage and housing crisis, while at the same time adhering to the master plan and the functional master plans of the county. Although not adopted as a functioning master plan, you heard from an earlier case a lot about the Climate Action Plan. I would submit, and you can take notice on the hearings and information that was provided at the time of the basic plan. We did a full analysis, this development did a full analysis with respect to how it supports and meets the Climate Action Plan, primarily as it relates to the environmental superiority that I've already mentioned. The 4-tiered habitat restoration programs consisting of wetlands, meadows, forest edges, and understory. Providing and preserving the Tier 2 Mattawoman Creek protected areas with buffers, easements, and dedication. Providing 100% on-site woodland conservation. Turning to the transportation network and circulation, you're likely to hear, as indicated in some of the opposition letters, both in this case and the other case, that there's a traffic issue in Brandywine. As a Prince Georgian my whole life, grew up in Upper Marlboro, went to public school until high school, went to DeMatha. Have to put that out there.
Too bad.
I know Mr. Chairman played basketball. I assume the risk by mentioning that, Mr. Chairman. But nevertheless, I would be remiss if I stood before you and tried to gloss over the fact that 301 and Route 5 is a heavily traveled roadway through the county, especially in South County. It is trafficked. It's caused primarily because of our growing neighbors to the south. And because of that, going way back to 1993, in the preceding master plan, the county came up with a concept as the Brandywine Road Club. Now, over time, that has been a blessing and a curse. It's been a blessing in the sense that we haven't allowed other jurisdictions to thwart our ability for economic development and growth, pursuant to our planning goals and policies. It's been a curse because I think the community, and to your point, Mr. Chairman, as far as getting the word out and making sure everyone is aware, because development in Prince George's County is very complicated. Understanding what the Road Club does and what the Road Club doesn't do. And I think for a lot of folks, they hear Brandywine Road Club and they say, oh, it's a pay and go. And for many years it was. For many projects it has been. Recently, however, and this applicant is no exception, as well as other applicants, we have tried, and with the help of staff and with the help of the administration, we look forward to working with the new administration as they kind of get their sea legs under them with some of these issues. Facilitating the ability to use the Brandywine Road Club as far as the funds that we put into it, which are millions of dollars for these projects. But not only to use that as an adequacy determination, but actually how do we get improvements on the ground? And what this developer or applicant, D.R. Horton, has done on a project to the north of here is executed developer participation agreements or letters of agreement with the county to use those funds to actually make improvements. This project is no exception. We have in our traffic impact analysis, which again, because the certificate of adequacy is approved, the traffic is really not germane to this hearing, although I think you're going to hear a lot about traffic in this case and the next case. We would like to use our Brandywine Road Club funds to actually use those funds to make improvements on the ground. I think we owe that to the citizens. I think we owe that to the county. And I can stand before you proudly to say that we have projects that are actually under construction right now for which road improvements to 301 are part of that application. Notwithstanding the fact they were approved, as this case hopefully, or the ADQ has been, and hopefully this preliminary plan will be approved with utilization of the Brandywine Road Club. The Brandywine Road Club does facilitate our ability to meet adequacy. It does not, though, end the conversation with respect to developers and applicants trying to utilize those funds to make actual road improvements. And the Road Club has facilitated improvements in the area. Regarding parks and recreation, we are proposing 141 acres to be dedicated to the commission for parkland. We are proposing a master plan Mattawoman Creek Trail constructed within the property. on-site amenities including clubhouses and over 10 acres of recreation, as well as, for Commissioner Geraldo, a dog park.
Dog park.
Dog park. We will have that. The preliminary plan is in fully conformance with the prior conditions of approval. That's analyzed in great depth in your technical staff report. I think in conclusion, Mr. Chairman, I would just note that, I know your binders are thick and heavy. This is mine. There is more than substantial evidence in this record to support this approval. I don't want to belabor the point. It's been a long day already. On your first day, I will tell you this is one of the more longer planning board hearings that we've had. And certainly we work hard with your staff. We do work hard with the community to try to make these cases kind of do the legwork on the back end. With respect to, I'll just close with just some of our efforts because I know it's going to be important moving forward under your leadership that all applicants get the message that doing the bare minimum is not going to be acceptable as far as outreach and trying to educate the community. I would just say, gratuitously, if I may, Mr. Chairman, it has to be a two-way street. I think the community members that you might hear from today, we know well. They're not novices. They're familiar with the process. We have fairly good working relationships with them. We don't always agree. We don't always get contacted, despite our best efforts. But I promise you, and I stand before you as a practitioner before this body and this board and this community, which has raised me up, that we will continue to do our outreach, and we will continue to do everything we can to make sure that the community is aware of these projects, notwithstanding we may not always get responses. To that end, going back to 2021, we held virtual hearings on the basic plan with a significant amount of outreach during that time to include all the statutorily required informational mailings, postings, et cetera. We held virtual meetings in 2023 for the conceptual design plan. We had all the requisite informational mailings and notifications with respect to this particular application. We have, and I hope Ms. Gray, who's here and I believe going to speak on this application, will agree that we have endeavored to always be communicative with her and her organization, as well as the other organizations in and around the Brandywine area. I don't want to go through the laundry list of efforts as far as what we've done, but let me assure you that since 2022, with the help of GS Proctor & Associates, as part of our community outreach efforts, we have always endeavored to make sure that the community is aware of what's going on. As I mentioned, we don't always have the answers that we agree on, but we always try to strive to make sure we inform and always try to strive to make sure that they have an understanding of the application, and where we can make concessions and where we can do things, we try to do them. In particular, with regard to this application, I will tell you that stems, and it's a condition of the approval or recommended a condition related to the road improvements. I think the biggest significant thing that this project and other projects in Brandywine can do is actually try to put their money where their mouth is with respect to the road club and actually facilitate improvements with those funds. We don't have control over that. There has to be a concession with respect to the county and the administration, but we've been pretty successful recently, and I plan and I expect that will continue. But we have proposed in our traffic impact analysis to use road club funds to construct a fourth southbound through lane along 301 and McKendree Road, as well as a northbound second left turn lane, which is reflected in your condition 4, recommended condition 4. So I think I will echo Mr. Gibbs in his prior case, where I will stop there, allow anybody who else has signed up outside of the applicant's team to provide any thoughts and comments that they may have, and afford the opportunity to respond back in rebuttal. And if I need to, have some witnesses help clarify things. But again, I just want to thank you for your leadership. I want to thank the board for its continued support of this application, which has been a long time in the making. We still have a long road to go, but we look forward to bringing this project to fruition as recommended in the master plan and as envisioned in the general plan and master plan under the current zoning. So thank you, Mr. Chairman.
Are there any questions for Mr. Tesco? I do. That was more of a statement as well. I love the fact that you are a lifelong Prince Georgian. And even though you did not go to High Point High School, I will not hold that against you. But one of the things that you said kind of struck in a chord when you said that the relationship has to be a two-way street. That conversations has to be a two-way street. And just as I said to Mr. Gibbs, I totally agree in the principle that we must create a win on both sides. That there has to be a win for you and your clients, but more importantly for me, there has to be a win for the community and the residents in which we serve. I love the fact that there is funds put aside for transportation improvement, which to me shows that you guys are getting it and looking at ways in which we can leverage relationships in more meaningful ways to improve our communities. I love the fact that you are being aggressive in saying that there are opportunities for parkland for this commission. To me, that shows that you are understanding the word in collaboration. And it is my hope that those that come before you or after you also understand that there has to be a paradigm shift in how we do business, not only within this agency, but throughout Prince George's County. The county executive has said and told me on numerous occasions that it will be a new day in Prince George's County, and her mantra will be that it is good business to do business with the people of Prince George's County, meaning that there has to be opportunities in which we win. And that is the philosophy in which I am embracing and that I am asking that this board also embrace, and the philosophy within the commission as a whole. I love the fact that you are embracing the fact that you are a resident of Prince George's County, which you hold dear to your heart, and that you are working to make improvements for this county and the betterment of its citizens. That I applaud you. So I am looking forward to working with you closely as the days and the weeks go long, and I appreciate the good effort and the good faith by you and your clients to make sure that we are moving in a direction where the community at large is happy. And I think once we have that, then we become a more vibrant community, and the county executive does what she intends to do, and that is transform Prince George's County into more than what it is. And I've always said parks and planning is a destination. It is not just for those that look at parks and rec, but it will become a destination for the world. And with your help and others in this room, I think that we can embark on those things in a more meaningful way. So those were my comments, not so much a question. But I'm glad that you heard my statement to Mr. Gibbs, and I hope that everyone else hears that, because I want it to resonate loud and clear, that how we do business, it must be more on a collaborative note in which we all create a winning atmosphere on both sides. Thank you.
Thank you, Mr. Chairman. And if I just may, I will not apologize for my graduation from DeMatha Catholic High School. I'll just blame my mother, who, is a Hyattsville, grew up in Hyattsville, was a graduate of Elizabeth Seton. So as the sister school to DeMatha, I kind of had no choice. That's where she was going to send me. So both my brother and I. But thank you, Mr. Chairman, for your words. We look forward to continuing the same dialogue in your vision. So thank you so much. I would just note for the record, so I don't forget, Ms. Varenduce indicated that we had applicants Exhibit 1 with a revision to Condition 18. Staff did have some objection with our proposed language in blue, and we do agree with what was read into the record to strike what's in blue and replace that with timing to be determined as specific design plan for the residential development as referenced by staff. We are in agreement with that edit to Condition 18. With that, Mr. Chairman, I will reserve any further time in rebuttal. Thank you.
Thank you. I know that there are several people that have signed up to speak. If there are any ones that have signed up in favor, you can do so. But if there is anyone in opposition, we would hear from you at this time.
Your name, please. Yes, ma'am.
I did sign up online and I did submit testimony.
Yes, ma'am.
Welcome, and I'm hearing what you're saying about community engagement. I'm going to go off of my testimony for a moment. I've been working with
3 minutes.
this park and planning since Commissioner Parker was in position, and I sat on the advisory board for this agency for 2.5 years. I understand what it means to have community engagement, and it's right. You have to have two-way conversation. I am a certified community practitioner and also an expert in Title VI in participatory engagement, involvement, and having a two-way conversation. And it does need to be a new day to have that. I am a community fighter, and it saddens me when community goes in the hallway and they're having issues because they don't feel like the developers are hearing them or listening. For me, it is that they come, they tell us what they want and what they're going to do, and that's what it is. And there isn't any room to move for what the community wants or what the community needs. I have been in this county all of my life. My mother just passed at 100. She has been here and worked for this county for 58 years. From what it was then when we were here with no roads, no development, our house wasn't even built, to what it is now. If we could have imagined that from then to now, it's very different. We could have never imagined it, which is what I should say. And it's not what we expected. I don't think it's what we wanted. Now, with this, the arguments about, and we're in opposition because it is the traffic. It's all about adequate public facilities. And instead of us fixing the problem, we alleviate it. We understand and acknowledge that CR 80 2025 passed. But for us as a community, it's a clear betrayal because a resolution does not repeal law. Section 24-4508 remains in effect. And unless and until CB 29-2025 or other legislation formally amends that statute, the board is bound by the law as it stands. Any less is arbitrary, capricious, and legally indefensible that for years, and we talk about the Brandywine program, it is not effective. It has not been effective. This is not theoretical. We sit in traffic. Brandywine is the most environmental polluted community in the United States. We do not address that. We keep putting cars and more traffic and people sitting in traffic for years. We are not anti-growth. We are pro-accountability. We're pro-safety. We're pro-law, and we're pro-community. And I think as a community, we have to come together and figure out how we fix these things. Because community's not happy, developers are probably not happy, and no, they don't like when we come here and complain. So I think that we need to stand on what's right and not where we go wrong. So I would just say thank you. And at this juncture, we feel that this should be denied, but we understand that they usually aren't, and we just will be more inundated. But thank you for.
Yes, ma'am. Thank you. Your name?
And I've written this and I spent a lot of time on this. And so I'd like to express my concerns with the opposition to.
Can you wait 1 second, Ms. Powell? Because I don't have you on my list.
Was on the list in the back on the computer.
She signed up when she paid it.
Okay.
Oh, sorry. Can I speak on Saddle Ridge? Yes, that's what I'm speaking on. No,
this is not that one.
I'll be back.
Is there anyone else in opposition? And if not, I am hereby ending the public testimony portion of this item. Board, are there any questions for those speakers? If not, Mr. Tesco, is there any rebuttal?
Thank you, Mr. Chairman. Very, very briefly, I just want to thank Ms. Gray for her comments. I've known Ms. Gray for, I don't know, 15 years or more, and I certainly can reflect upon many conversations and meetings that we've had together, both myself and Mr. Steve Proctor, along with others on various projects in Brandywine. And she is a steward of her community. She is passionate about her community, and I applaud her for that. And yes, certainly Brandywine has changed from even from when I was a kid growing up in Upper Marlboro, but that change was always planned. Actually, from 1993, the plan for Brandywine was more heavy industrial. That changed with the rezoning of the Brandywine Shopping Center, when it was taken from industrial and residential and other zones into commercial. Since that time, it's one of our centers in the county, one of our 26 centers, if my number is correct, in the county. It's slated for growth. Understanding, however, that growth comes with change. Understanding, of course, that change can be hard. The reality of the situation is that this has always been planned. I know that it's not a good answer for many who may not have that familiarity or that history. Notwithstanding that, the issues with 301 and 5 and that corridor go far beyond Prince George's County. Prince George's County has done what it can through not only through developers, but through legislation to alleviate those issues. But to stand up before you and say the road club has failed, I have to correct that statement with all due respect to Ms. Gray. The Brandywine Road Club, while it has facilitated development, it has also facilitated the Brandywine Crossing Shopping Center, which as part of the road club, constructed a 4th northbound through lane, US 301 in Clymer and Chatsford. Part of the project that D.R. Horton's actively constructing now, constructed a 4th southbound through lane on US 301 for about 2,000 linear feet. It dedicated and constructed A55, an arterial roadway from US 301 to the western limits, including the connection to General Lafayette. Village of Timothy Branch, another large comprehensively designed project, constructed the arterial roadway connecting Brandywine Road to the shopping center, giving local residents a relief valve to not have to get on 301 and 5. For Stevens Crossing, dedication and construction of A63, another arterial road. In the harmony of Brandywine, the construction of a portion of Branch Avenue, safety improvements contemplated by SHA. It doesn't happen overnight, but it is happening. Does that mean there's no traffic on 301? No. We know that. Notwithstanding the fact the county has recognized that and why the road club exists. With respect to the response times, I do not believe they're constitutional. I've submitted a 50-page memorandum to that effect, notwithstanding we've accepted that condition based upon CR 80. We are not trying to get around anything, but the law is there to protect not only citizens, but the applicant as well. So with that, I will just say that based upon the analysis that was done, based upon the law as it exists for this county today, adequacy is met through the payment of a mitigation fee, which is not inconsequential. I think it's about $8 million total. In addition to the public safety surcharge, that is about $10,000 per unit. So you can do the math on that with respect to how that is dealt with. We are mitigating the impact, and for those reasons, the certificate of adequacy has been approved. Traffic is not the subject of your approval today. It's already been approved as far as an adequacy determination. And so with that, Mr. Chairman, based upon this record, based upon the substantial evidence, and based upon the contentions that have been made on behalf of the applicant, and as recommended by your staff, we would respectfully request that this preliminary plan be approved. Thank you. As recommended by staff, the applicants provides condition 18 as read into the record. For the motion maker.
Are there any questions for Mr. Tesco? Seeing none, board members, are there any deliberation and if not, what's your pleasure?
Mr. Chairman, I move that we adopt the findings of staff and approve preliminary plan 4-24014, TCP 1-011, 2023-01, variation from section 24-128B7A, and variance to section 25-122B1G, subject to the conditions as outlined in staff's report, and condition 18 as modified by applicant exhibit number 1, and is further modified by staff as read into the record, and then subsequently modified by the applicant.
Second.
We have a motion by Commissioner Washington and second by Commissioner Giraldo. I will now call the roll. Chair Bailey.
Aye.
Vice Chair Bailey. Commissioner Washington.
I vote aye.
Commissioner Giraldo.
I vote aye, Mr. Chair.
And I vote aye as well. The ayes have it. This will be recommended. Okay. Thank you. We will now move on. 8A was removed, right? 8B. We will now move on to the next item, item 8B, preliminary plan subdivision 4-4013 Saddle Ridge. Staff.
Good afternoon, Mr. Chairman and members of the board. For the record, I am Jason Bartlett with the subdivision section. Item number 8B on the agenda is a preliminary plan of subdivision for Saddle Ridge, case number 4-24013, which proposes 783 lots and 97 parcels for residential development consisting of 530 single-family detached and 253 single-family attached dwelling units. Before I continue, staff would like to note that the published technical staff report recommends disapproval of this preliminary plan based off the denial of the accompanying certificate of adequacy for this case. However, since the technical staff report was published, the certificate of adequacy was considered by the planning director as allowed under Council Resolution CR-A-2025 adopted this past Tuesday, and the certificate of adequacy is now approved with conditions. Therefore, staff is now recommending approval of the preliminary plan, which is supported by the findings and conditions provided in the published technical staff report, and now supported by approved certificate of adequacy 80Q-2024-019. In addition, staff received 7 items of additional backup for this case prior to the noon deadline on July 8th. These items are provided as additional material and include applicant's exhibit 1, which is a request for a revision to condition 18 in the technical staff report, and opponent's exhibits 4 through 9, all of which will be discussed further in my presentation. Turning to the presentation, this first slide being displayed is the aerial image, the proposed subdivision outlined in red. As can be noted, the property is vacant and wooded, bound by a roadway to the north and south, and bisected by an approximate 300-foot wide strip of land owned by the Pepco by the Potomac Electric Power Company. Next slide, please. General location map shows the site is generally located in the south central part of Prince George's County within planning area 85A and council district 9. Next slide, please. More specifically, the vicinity map shows the site outlined in blue and lying on both the north side of MD 373, Accokeek Road, approximately 3/4 miles west of its intersection with MD 5, Branch Avenue, and on the south side of Floral Park Road, 1 mile west of its intersection with MD 5. Thereby having frontage on both roadways. The site vicinity map also shows that the site has varying topography with slopes indicated around Birch Branch Creek running through the property. Next slide, please. The zoning map shows the property lies in the Legacy Comprehensive Design Zone, shown on the map to the right. And however, the current zoning, notwithstanding, this application was submitted for review under the prior zoning ordinance and subdivision regulations. And therefore, this application was reviewed according to the standards of the prior residential suburban development, or RS zone, in which the property was located prior to April 1st, as shown on the left. Next slide, please. This slide shows the site has frontage on a master plan right-of-way to the south on MD 373, a master plan collector roadway, and on Floral Park Road to the north, master plan primary roadway. Next slide, please. This slide shows the overall preliminary plan with the boundary of the property outlined in red, public rights of way in dark blue, private rights of way in light blue, and the primary management area, or PMA, outlined in dashed pink. As detailed on page 14 of the technical staff report, 3 access points are provided to the site along MD 373, and 2 are provided along Floral Park Road. Next slide, please. The slide shows the type 1 tree conservation plan with property boundary outlined in red and the primary management area again indicated by the dashed pink line. 91.62 acres of woodland conservation is required with this application, which is proposed to be met through a combination of on-site preservation and reforestation, highlighted in green, as well as a small amount of off-site woodland credits, all of which is discussed in the technical staff report on page 25. The applicant has further requested a variance from section 25-122B1G of the prior subdivision regulations for the removal of 54 specimen trees as indicated by red dots on the TCP1. This is discussed further in the technical staff report on pages 25 through 28. Impacts to the PMA have been previously approved for infrastructure, and these 3 impacts are requested with this subdivision. All impacts are indicated on this slide by the letters A to X. These impacts are discussed in detail in the technical staff report on pages 28 through 30. Those 3 impacts associated with this preliminary plan are specifically to accommodate trail and roadway improvements. Next slide, please. The dedication exhibit shows the parcels proposed to be dedicated to the Maryland National Capital Park and Planning Commission in pink. Land dedication is required as a condition of approval with a comprehensive design plan, CDP-22001, which is discussed in the technical staff report on pages 7 and 10, or 7 and 11. And 102.87 acres is shown to be conveyed to MNCPPC on the preliminary plan of subdivision. Next slide, please. The open space rec facilities exhibit shows the location of the private on-site rec facilities proposed to meet the mandatory dedication of parkland requirement for this subdivision. As noted on the exhibit, these facilities are generally evenly dispersed around the development with the clubhouse in a central location. Staff find these facilities will be sufficient to meet the mandatory dedication of parkland requirement in accordance with the 2024 Park and Recreational Facilities Design Guidelines, as discussed on pages 11 and 12 of the technical staff report. Next slide, please. The circulation and trail network exhibit shows the sidewalks proposed on the site, as well as the master plan trail and its proposed alignment, which extends the trail connection through the property to Floral Park Road. The trail connection is discussed on pages 11 and 12 and throughout the technical staff report. Next slide, please. As mentioned at the beginning of this presentation, staff received an exhibit submitted by the applicant as backup material for this case. In this exhibit, the applicant requested a revision to condition 18 related to the timing of the proposed trail construction. Staff has reviewed the proposed revision and recommends the applicant's proposed language in blue at the end of the condition be replaced to state with timing of the trail construction to be determined at the time of the specific design plan for the residential development. It is staff's understanding that the applicant is in agreement with the revised language as recommended by staff. Additionally, staff received 5 items in opposition for this case in support of staff's initial recommendation of disapproval entered into the record as opposition's exhibits 5 through 9, or opponent's exhibit 5 through 9. These letters express concerns regarding the failing police response time. However, the evaluation of police response time is outside of the scope of this preliminary plan and are determined under the certificate of adequacy. Specifically, the opponent's exhibits include a letter from the Villages of Savannah Homeowners Association Board of Directors, a letter from the Brandywine TB Southern Region Neighborhood Coalition, and the Executive Community Citizen Board, or ECCB, Neighborhood Leadership Council, and 3 letters from 2 homeowners in the surrounding community, one being an update to one of the letters previously submitted. Lastly, staff received 1 letter from the Prince George's County Council Budget and Policy Analysis Division regarding the public facility adequacy findings entered as opponent's exhibit 4, consisting of 91 pages. In conclusion, subdivision staff recommends the planning board adopt the findings and approve the preliminary plan of subdivision 4-24013 Saddle Ridge, Type 1 Tree Conservation Plan TCP 1-012-2023-01, as well as the variance from section 25-122B1G, subject to the findings and conditions in the technical staff report, with modified condition 18 in accordance with applicant's exhibits 1 as further modified and read into the record by staff. This concludes staff's presentation.
And any questions from the planning board? Mr. Tesco.
Thank you again, Mr. Chairman, and hopefully you're not getting tired of me with 3 back-to-back cases, but
Prior to your case, swear in everyone who is seeking to testify in this matter. And everyone online as well, if you'd raise your hand. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes,
I do.
I do.
Good afternoon again, Mr. Chairman, members of the board. Matthew Tedesco with the law firm of McNamee Hosey and Greenbelt, here on behalf of the applicant, D.R. Horton Incorporated. As indicated on your sign-in sheet, we have a number of individuals similarly to the last case that are signed up, but do not necessarily need to speak today unless called upon either by me or you all in rebuttal or in response to any questions that I'm unable to answer. But again, we have a number of representatives from D.R. Horton. We have a number of representatives of the design team from Rogers Consulting, both environmental and land planning and landscape architecture. We have representatives of my team, Dominic Lockhart and Carly Landolfi. And we have Mike Lenhart from Lenhart Traffic and Consulting. Again, gratuitously, just Mr. Chairman, as you know, with the adoption of CR 80 2025, the planning director reconsidered the certificate of adequacy in this case and recently approved that certificate of adequacy, which kind of change the posture of staff's recommendation for the preliminary plan. We have executed a mitigation agreement related to that certificate of adequacy, but notwithstanding, if you would allow me again, just to gratuitously pad the record with the following statement, notwithstanding the execution of the mitigation agreement, the ADQ conditions of approval, the applicant expressly does not waive any legal objections or rights to later appeal or challenge the police response time test and mitigation agreement resulting from the ADQ conditions. We explicitly reserve all rights to challenge the validity, legality, and constitutionality of the application of the police response time test and imposition of the conditions and mitigation. Accepting the ADQ conditions and execution of the mitigation agreement is made solely to avoid the only alternative imposition of unconstitutional conditions that would result in undue delay or obstruction of the underlying project and approval of preliminary plan 4-24013. It's been a long day. I don't want to be overly redundant, but similarly as the last case, Dobson Farms, this case also has a very long history of surface mining activities and operations, being sand and gravel, going back more than 50 years. Similarly, the design team for this case envisioned, as well as the Subregion 5 master plan, goals and policies for the property to create the best possible land plan while preserving and enhancing the property's unique environmental features consisting of the Birch Branch and associated tributaries, creating a very unique and special, well-planned design community. There is no doubt, as supported by the staff and all reviewing agencies, that this preliminary plan continues to build upon and remain consistent with the basic plan, the conceptual design plan, and the specific design plan that was recently approved, and further advances the vision and goals and satisfies all of the required findings of approval. This case, too, has a very long history going back to more than 5 years, going back to the basic plan. This body has recommended approval not only of the basic plan, but the conceptual design plan, as well as last year on my birthday, approving the specific design plan for infrastructure last June. So that was a nice gift. As I mentioned in the last case, as these projects move through the iteration and get further designed and refined, oftentimes the density gets adjusted. As this project was approved with the basic plan A-10060, it was approved for no more than 955 units, still within keeping of the residential low land use recommendation of the master plan and the general plan. Again, residential low being 3.5 units to the acre. As I stand before you this morning, we are down to not 783 residential units, 530 of which are single-family detached residential units. Only 253 are single-family attached. Of those, I want to point out, and I neglected to do so in the last case, of those are, especially in the northern pod quadrant north of the Pepco transmission lines, we are proposing, and you will see this at subsequent applications for the specific design plan for the residential development itself, villa model product type for aging in place and having the main bedrooms on the ground floor with garages. So again, with projects of these size, the varying of product type, it enables the builders to do a couple of things. One, have various models and various price points to help with the housing crisis and help with home ownership, which is the single most important thing that especially our young folks, scary for me to say that as I'm approaching my 50s, but our young folks can afford hopefully housing types in the community that are otherwise they're priced out of sometimes. So we have a mix of product types which have been successful throughout the region, throughout the county, predominantly being single-family detached, somewhat in keeping, more so in keeping with the character of the area. But I will also note that similarly as Dobson Farm, this particular project in the 2013 Subregion 5 Master Plan is actually referenced by name. It references Saddle Ridge in the master plan as a contributing potential future development, a large-scale future development, albeit keeping with the recommendation density requirements to support the Brandywine Village Center of the general plan. And that's precisely why this board and ultimately the district council approved the rezoning 4 years ago to rezone this property to a comprehensive design zone to provide flexibility in keeping with the master plan's goals and policies, while also creating flexibility for the development of this scale to be able to facilitate what the plan envisioned. Again, just to reiterate, 3.5 dwelling units is the maximum allowed on residential low. This proposed plan is at 2.87. I did want to mention, as Mr. Bartlett indicated, with respect to the environmental stewardship, not different than the last application, this application has a significant amount of on-site preservation and reforestation. The required woodland conservation is 91 acres, only 3.6 acres of which will be off-site. The remaining will be provided on-site through preservation and conservation. The Birch Branch Stream Valley, which one of the slides, I don't have a reference, but one of the slides showed how that impacts the subject property with its associated primary management areas. That equates to approximately 102, call it 103 acres, which we will convey to the Commission for Parkland. There will be a master plan trail, no different than the last application, that will support not only this development, but also the region as well. Although not the subject before this application, given the fact that the certificate of adequacy has been approved by the planning director, all public facilities have been deemed adequate with mitigation payments. On-site recreational amenities and public benefits include on-site facilities offered in lieu of the parkland, clubhouse, pool, fitness center, playgrounds, dog park, community garden, and master plan trail. The plan is fully consistent with the prior approvals, both the CDP, the basic plan, the SDP for infrastructure, master plan, as well as the general plan. Adheres to the intended development densities. The tree conservation plan and specimen tree variances comply with all applicable environmental and legal standards and reflect a significant effort to preserve sensitive features. The proposed recreation amenities exceed the required standard and will greatly benefit the future residents. And the development achieves many goals of the master plan and Plan 2035, including the preservation of the green infrastructure, provision of varied housing types, and implementation of stormwater and environmental practices. We would submit and adopt as further testimony our justification statement, as well as all the justification statements associated with the variance and the variation. We accept staff's recommendation. We did have one exhibit, applicant exhibit 1, which proposed revision to condition 18 as further modified by Mr. Bartlett. We are in agreement with those additional modifications. No different than the last application. We have, over the last 5 years, engaged in significant outreach, but as I mentioned before, I will incorporate and adopt the comments before with respect to outreach so as to not belabor the point. But it does need to be a two-way street for which we look forward to continuing to work with many of the residents in the area, to include Ms. Gray and others who may speak this afternoon, and I will address those in rebuttal as needed. With that, Mr. Chairman, we would respectfully request your approval of this preliminary plan of subdivision as recommended by staff. We accept the condition as modified by the applicant's exhibit 1 and further modified by staff's reading of the revised condition 18 into the record. And if aren't any questions, I will reserve the rest of my time for rebuttal. Thank you.
Thank you. Are there any questions from the planning board?
No questions.
Seeing none. There are several individuals that have signed up to speak. If you are in favor, once again, it's not necessary unless you want to, but there are 5 individuals in opposition. Ms. Kamita Gray. She just walked out. Well, we'll come back to her. Louise Galen.
Good afternoon, Mr. Chair. I would like to request for 5 minutes to speak on behalf of the Villages of Savannah Homeowners Association, which is being affected by this proposal.
Unfortunately, we will allow you 3 minutes.
Okay.
If she's an officer, she is allowed 5 minutes.
Are you an officer?
Yes, I'm the board of director of the HOA in the Villages of Savannah. Thank you, sir. And congratulations. It's nice
Thank
to
you.
work with you. Thank you for your first day.
Yes, ma'am.
Good afternoon, members of the Planning Board, county staff, and fellow residents. For the record, my name's Louise Galea, and I serve as the Board of Director for the Villages of Savannah Homeowners Association located in Floral Park Road and Brandywine Road. I appreciate the opportunity to speak before you today regarding the proposed Saddle Ridge development, PPS 4-24013, in firm opposition for this proposal, not only as a resident, but a concern as a steward of a shared public resource. I wanted to highlight several serious concerns that deeply impact our community's safety, environment, infrastructure, and overall quality of life. Before I go into critical planning issues, I must first express our community's deep disappointment regarding the lack of community outreach by the applicant. The Villages of Savannah HOA board and our residents were not really contacted or consulted by the developer and their legal representative before the application. Given the direct and substantial impact of this development would have in our community, this omission is not acceptable and contradicts the principle of the transparent, inclusive planning for the Prince George's counties upholds. And Mr. Chair, I would love how you advocate bridging that relationship between the applicant, developers, the representatives, and the local community residents for these developments. And I hope we can do more of that. First and foremost, of course, as prior to the approval of CB 29-2025, this project has been denied a certificate of adequacy due to the failing police response time in District 7. The PG Police Department has made it clear that these services gap cannot mitigate under the current system of this public safety, and it is not negotiable. Adding nearly 800 homes without adequate protection jeopardizes every household in this area. Next would be inadequate transportation infrastructure. The strain this development would place in our already congested roads is unsustainable. Floral Park Road, Brandywine Road, and Accokeek Road are not equipped to handle influx of vehicles that would come from Saddle Ridge. The staff report explicitly noted that the road widening and other infrastructure enhancements are necessary. Without them, we will face increased accidents, longer emergency response time, and daily degradation of commuter experience. Overburden of school. While we acknowledge that Plan K-8 school in Gwen Park Middle School, that will not solve the core issue here. New elementary and middle schools are still critically needed on the east side of Route 5 and 301, the very area where this development is being proposed. Of course, approving Saddle Ridge now will compound an already unmanageable educational burden and shortchange our students. The health and services deficiency. This health infrastructure in Brandywine is simply not ready to support community of this magnitude. While we've seen minor improvements, we still lack a modern full-service hospital, and residents often must travel significant distances for specialized medical care. Adding hundreds of families in this area without addressing this gap would be very irresponsible. Environmental degradation. The proposal involves clearing 125 acres of woodland, including the removal of 54 specimen trees, many in good condition. These trees are surrounded with woodlands providing critical environmental services such as stormwater absorption, wildlife habitat, cooling in the face of rising temperatures. Let us not forget that this land includes the Birch Branch Stream, a tributary to Piscataway Creek, which is classified as a Tier 2 waterway with high ecological value. Once the sensitive area is disturbed, we cannot get it back. And also community planning and smart growth. This proposal fails to uphold the PG County's vision. Plan Prince George's County 2035 and Subregion 5 Master Plan both call for context sensitivity and environmental responsible development. The Saddle Ridge Plan, despite meeting density targets on paper, disregards the spirit of those plans by fragmenting woodlands, burdening infrastructure, and straining the public services designed to supporting our communities. And lastly, we have inadequate recreational planning. The developers plan to provide on-site recreational amenities in lieu of parkland dedication is also flawed. Many of the proposed recreational parcels are overlapping with stormwater facilities, raising concern about safety and usability of families and children. In conclusion, the proposal fails to test of safety, sustainability, and smart development. The planning department staff have made a clear and compelling case for disapproval prior to all this. And I respectfully ask the planning board to stand with the staff's recommendation to disapprove this preliminary plan. This proposal is not ready, not safe, and not aligned with our shared vision for Prince George's County. Our communities deserve better planning, better support, better protection for our families who are currently living in these communities. And I would like to thank you for your time and commitment to this responsible planning. Thank you.
Thank you, Ms. Gray.
Good afternoon, Kamita Gray for the record. I'm going to waylay my testimony and just say I want to ditto what I said the last time. And I think that hoping that it's a new day and moving forward and that we have to find a way to work together with the community and the developers and the applicants and the attorneys to get the best that we can do for Prince George's County and moving forward. Thank you very much.
Thank you.
Thank you.
Carleen Powell.
Good afternoon. I told you I'll be back. Again, I am Colleen Powell. I am a lifelong resident of Brandywine, and I reside on the northeast side of Moores Road at the intersection of Branch Avenue. We and the residents on Moores Road, east and west, oppose to the approval of the preliminary plan to subdivision 4-320413 in Saddle Ridge. Residents on East Moores Road opposed this development because of the impact it would have on Branch Avenue going north, passing Moores Road. That's where our difficulty is. Some of the other reasons are lack of infrastructure in Brandywine, such as public facilities, public safety, transportation, police and fire services, heavy traffic flow and backups southbound starting at Woodyard Road to the light at Brandywine Crossing Shopping Center, heavy traffic flow and backups northbound from Spine Road passing Moores Road, Earnshaw Drive, and Birch Hill Road to Surratt's Road. No adequate alternatives to entering or exiting East Moores Road into the intersection safely. Branch Avenue reduces from a 6-lane highway to 4 lanes, reducing traffic flow northbound and southbound. There's a long wait time exiting into the Branch Avenue and Moores Road intersection to enter onto the highway and crossover. There's only a caution light, yellow red caution light there. There's no signalized stoplight. Lack of use of Brandywine Park and Ride due to tractor trailers occupying area. Issues resulting in possible car damages, car insurance coverage due to damages. Actually, many of the residents or even motorists that go north or southbound are not using that. There's probably less than 10 cars that you would see, or maybe less than that's using the park and ride. Lack of widening of narrow roads such as Floral Park Road, Brandywine, and Accokeek Roads. There have been serious and fatal accidents at the Branch Avenue and Moores Road intersection. There's been a lot of aggressive and recreational drivers on Branch Avenue, north and southbound. The location of the proposed Saddle Ridge subdivision is approximately less than a mile from Branch Avenue. Branch Avenue is the most direct state highway from 301 South merging onto Maryland 5 north of the Capitol Beltway in D.C. Additional traffic merging into traffic coming from southbound would delay responses to accidents and unexpected roadway emergency. And as I stated before, we've had many serious and fatal accidents there. I have a quote from Maryland Department of Transportation Innovative Contracting Division Transportation Engineering Manager, and it states, to provide further context to the concentration area of Maryland 5 in this area from south of Brandywine Road to just north of Earnshaw Drive, the original southbound lane of Maryland 5 was constructed in 1956, and the northbound lane was constructed in 1969. There has not been any expansion or capacity improvements of Maryland 5 in this area since 1969. There have been many operational improvements since that time, such as auxiliary lanes for left and right turning movements, but no roadway expansion. There should be no justification for adding additional housing at this time due to the lack of infrastructure. It is not fair, I believe, to bring families into this area knowing of its lack of adequacy in areas such as public safety, public responses, and so on.
Ms. Powell, your time is up. If you'd like to conclude.
Yes, just to add as an FYI, there was to be a development of a K-8 school, which that development is still to take place, but instead of it being K-8, it will be 3 to 8, and then grades K-2 will remain at Brandywine Elementary School, including Baden. So it's just saying the population has grown.
Yes, ma'am.
Thank you.
Thank you. Ms. Tamara Brown Davis.
Yeah, mine.
Mark Carhoon. Neither one of them are here. But at this time, I am hereby ending the public testimony portion of this item. Planning Board, are there any questions for the speakers?
No.
If not, Mr. Tesco.
Thank you again, Mr. Chairman. I think a couple of weeks ago, I stood before the board and I said, sometimes as the lawyer, I have the enviable task of preservation of the record to maybe not be popular. I know we all took an oath. I just need to clarify a couple of things that Ms. Gallia testified to under oath. I think her quote was that for the applicant, the attorney, that would be me, has done no outreach. I have an email to Ms. Gallia that I sent 2023 in September. And if I could, just for the board's edification, just read the email.
Yes, sir.
September 29, 2023, 9:50 a.m., an email from me to Ms. Gallia. Good morning, Ms. Gallia. James Hunt added me to an email correspondence that you and he were having, and I wanted to make sure we were proactive and immediately reached out to you. Please know that we have been in contact with Ms. King, copied, and others who attended the community outreach meeting that we hosted earlier this month. To ensure that the material that was shared at the meeting is provided, I've attached it here to this email. Please let me know if you have any questions or if you would like to meet. I have copied the entire development team to ensure you have everyone's contact information, but please feel free to reach out to me directly as needed. Finally, so you have it, below is the email that we sent to all of the attendees who attended the outreach meeting, as I wanted to make sure that you also had that information as well. We remain available to meet and answer any questions that you may have.
Yes,
I'm sorry.
Mr. I would like to respond.
I'm not finished, Ms. Gallia.
Sorry.
I'm trying to rebut your testimony that you provided under oath. In response, on Friday, September 29, 2023 at 9:58 a.m., Ms. Gallia said, "Dear Matt, thank you for providing me with this information. This is indeed very helpful to us. I do appreciate your proactiveness in getting our community involved. I will share this information to the Villages of Savannah Homeowners Association. We will keep in touch." That was the last interaction I've had with Ms. Gallia. Although she is a party of record, she and her husband have individually received informational mailing letters, acceptance mailing letters. The Villages of Savannah have received informational mailing letters as well as acceptance letters. We have posted the property. We had meetings dating back to at the Union Bethel AME Church, March of 2024. I've reached out to Mr. Calhoun numerous times, who refuses to meet with me. We have had meetings with Mr. Rodney Taylor and his community group at the Union Bethel AME Church. Ms. Gray, I know she came up here and said that she was adopting, but she will acknowledge I've had outreach and meetings with her. And Mr. Chairman, although I fundamentally believe that, my comments in the last case with respect to having a two-way street is important, it was also purposeful. It needs to be two-way. I did everything that I could, continue to do everything I can, and remain willing to meet with anybody who's willing to meet with us. But short of what we've done and then coming to a hearing to say we've done nothing, I think it is somewhat off-putting. I'll put it that way. With respect to the other comments Ms. Gallia made regarding supporting the staff recommendation, I stand before you hoping that you do support the staff's recommendation because staff is recommending approval. So I would echo that, notwithstanding. Ms. Powell, I want to applaud Ms. Powell. I will tell you that I can't think of a hearing on this application that Ms. Powell has not attended. I welcome the opportunity publicly for Ms. Powell, Ms. Gray, and all of us to continue to meet and dialogue. I know myself, Mr. Proctor, and his team, represented here today by Mr. Monroe Harrison, are always amenable and willing to meet with everybody and anybody that has an interest in the project. Ms. Powell lives off of Moores Road. Moores Road and that intersection of Route 5 is dangerous. SHA has plans to shut that median break down. They've made some safety improvements to that intersection by putting a blinking beacon there. Does that solve the problem? No, it doesn't. It's better than it was. But over time, SHA will, in fact, close that median break to make that intersection safer. Finally, similarly as the last case, this application does meet adequacy vis-a-vis the payment of the Brandywine Road Club. But as part of our traffic impact study, Mr. Lenhart and his team identified two intersections at the recently completed interchange of Maryland 5 and Brandywine Road, Maryland 5 Service Road at Brandywine Road, and on the west side of Maryland 5 and Maryland 5 Service Road and Maryland 373 on the west side. As part of the traffic impact analysis, recommended using road club fees to make improvements at these two intersections and identify the specific improvements that would be needed to achieve the adequacy. As staff found in its memo dated May 6, 2025, the revised study identifies specific improvements at two intersections that, if implemented, would bring the intersection within adequate requirements. So again, I know a lot of folks say, well, how does this benefit my community? The reality is, I think, Mr. Chairman, you'll see this over time, the county doesn't build roads. The state really doesn't build many roads, certainly not in Prince George's County. The way that roads get built in this county is through developers. And that's a necessary evil. I get it. It's not something that is popular, but that's the reality of the situation. We have an opportunity through this development, not only to convey parkland to the commission for the betterment of the community, which otherwise doesn't get the benefits of the Birch Branch. We have the opportunity to build a master plan trail, both at this project and the project to the south, to hopefully one day be able to connect all these trails. There is a master plan trail system in Chatsworth and other parts of Brandywine currently, but they kind of dead end. The vision and the plan of the master plan is to connect all these facilities. This project will help facilitate that. This project, if we are able to negotiate with the administration to utilize our share of our road club fees to actually make improvements, can make actual improvements as recommended by our traffic engineer to help the ongoing situation. And finally, we are required under the county code to make frontage improvements along all of our frontages to both Flora Park and Accokeek, which will be consisting of widening, sidewalks, street trees, street lighting, subject, of course, to DPI approval. All of those things help in bringing development in the community more in line with, well, what do we get out of this other than more cars? And I stand before you, providing housing is another necessary amenity that this community desperately needs. So with that, Mr. Chairman, I thank you for your time. I thank you for your consideration, and we would respectfully request that you approve this preliminary plan as recommended by staff. Thank you.
Are there any questions for Mr. Tedesco?
No.
Seeing none, board members, are there any deliberations? And if not, what's your pleasure?
Mr. Chairman, I move that we adopt the findings of staff and approve preliminary plan 4-24013, TCP 1-012-2023-01, and variance to section 25-122 B1G, subject to the conditions as outlined in staff's report, and condition 18 is further modified by applicant exhibit number one, and is further modified by staff and read into the record.
Second.
It's been properly moved by Commissioner Washington, second by Commissioner Geraldo. I will now call the roll. Vice Chair Bailey.
But aye.
Commissioner Washington,
I vote aye.
Commissioner Geraldo,
I vote aye, Mr. Chair.
and I vote aye as well. The ayes have it. This will be sent on for recommendation as well. This concludes all items for today's agenda. All important questions of the day, please ask Ms. Cherie Connor to confirm that there is no further business to come before the planning board today. The meeting is now adjourned.